Good morning, everyone online and in the room. Our first session today is with Shelley Weissman and Sazula Badan, and we're going to talk about recovery and the law. Shelley Weissman is an attorney. She's my colleague both at the Master of Science in Addiction Policy and Practice program and at the O'Neill Institute. Shelley worked for the governor of New York for a number of years, and also now is just a trusted colleague on so many of these issues and brings her important voice and perspective on the law. And then Sazula Badan is an attorney also who is licensed to practice law in 3 states, as I recall. So sign up for those CLE credits. Sazula is also a graduate of our Master of Science in Addiction Policy and Practice program. She has a wealth of experience, both personal expertise as well as legal expertise, and I look forward to hearing both of you. And for anyone online, we will get to your questions after both of our speakers present. So with that, we'll leave it to you. Thank you.
Thank you, Regina. Hey, everyone. Good morning. First of all, thank you, Regina, for organizing this. This has been just so freaking cool. I loved the day yesterday. I'm so excited to be talking about recovery in the law this morning. These are 2 topics that I am incredibly passionate about, both personally and professionally. I just, want to say how it was just so cool yesterday to see so many people coming together, people from, all different kind of perspectives in the audience and our speakers. From hearing about like the neuroscience of addiction, which, you hear about and know about, but like, to me, it was really cool to see like all the diagrams of the brain and stuff. And like those circles of how the treatment system has changed with moving more towards like the for-profit models and what the implications of that, and the Major League Baseball talk, that was really cool. And, what states like Massachusetts are doing. I just thought it was really just a breadth of expertise and like the policy stuff peppered in. And having so many of our Georgetown students and alumni here is just really, really cool. Shout out to our current and former students in the room and on Zoom. And also so many people, you guys who are change makers in this field, who are doing really amazing work. So many of you are saving lives every day, whether you know it or not, whether it's like from a clinical perspective, if you're writing about these issues in the press, if you're in a policymaking role or talking about your former experience as a policymaker or an advocate or opioid settlement boards or state folks, like whatever perspective it is, it's, I also think I know many of you in the audience, and I know that a lot of you have turned your own kind of personal story of, something difficult that you went through, either personal or with family or both, and turning it around to be useful to somebody else. And not just helping people live, but helping people to thrive and feel safe and feel supported. And it's just really incredible. And I just wanted to take a moment to remind everybody of that the work that everyone in this room, and I know pretty much everybody here, and the work that every single one of you is doing is really incredibly important. And that's what recovery is. That's what recovery is. You go through the lowest point in your life, sometimes over and over again. And you come out on the other side like a new and a different person, but someone who can feel truly useful, maybe for the first time ever in your life. And it's hard, it's messy, but it's really, really transformational. And I know that so many of you in this room have been through something like that or have supported a friend or a family member. And that's why we're all here. And so today, Sazula and I are gonna talk about the role of the law and legal representation in supporting someone's journey to transformation. We're gonna talk about I'm gonna talk a bit about kind of the big picture and the system work at hand. And Sazula is going to talk about some case studies and individual representation, which is something I think that we like come often as in the public health world don't really think a lot about or talk a lot about. So I think it's going to be really good. And, you know, everybody's story is different. I think how you came to this work, just like everyone's story is different, how they, you know, if they've come into their journey of personal experience. Hi. And, you know, so I work at Georgetown now, as Regina said. I've been here 7 years almost, which is crazy. And, you know, doing national policy work and teaching and mentoring students. And I've heard many, many stories from across the country of, you know, people's journeys and struggles. Before this, I worked in state government in New York, and I had like a really uniquely New York perspective. And I also represented, as a lawyer, people with serious mental illness, people with substance use disorder who lived in institutions for about 6 years doing like housing court, family court, suing the government, you know, and so many of those folks had very varied experiences. And I have my own personal story as somebody personally in long-term recovery. And, you know, seeing the journey of people in every community that I've lived in different states around the country. I'm a military spouse, and, you know, seeing different kind of experiences. And one thing I've learned throughout this is that there's no single recovery narrative. You know, like my story is very different than Sazula's story. I came into recovery as a teenager. You know, that's a very different journey than, you know, maybe many other people in this room, or maybe very similar to other people in this room or people that you know. And it's different than the story of someone who lost somebody close to you, right? And that's what drives this work. So before we kind of jump into defining recovery, whatever that even means, you know, I wanted to start with you guys in the audience and on Zoom. We're going to do, you know, thinking about your own journey, either if you personally have lived experience with substance use or struggle with substance use, or, you know, think about somebody that you love or somebody that you've served, someone you've gotten close to or advocated for or represented, you know, or who have met along the way that really kind of had an impact on you. You know, have that in mind. We're going to do 2 little polls that we hope technology will. I was sitting in my hotel room last night and I was like, you know what would be fun at 9 a.m. is, you know, something interactive, something wake everybody up. Yes. So you can click the QR code up there on your phone. And, you know, I'll give folks a minute. So this question is, and this is, you can answer more than one answer. So, you know, what was an impactful turning point in your recovery journey, or on the journey of the person, you know, think about one person that you have in mind, a loved one or a client or patient or somebody, you know, thinking about what it is, what was either the thing or the things, you know, was it, you know, when you went to treatment? Was it when you went to jail? Went to the hospital? When you had a child? Did that change things? Or when you got on medication? Was that the big game changer? When you found God or had a spiritual experience? Was it one person who said the one right thing at the one time in the moment that like just clicked and like turned it all around? Was it getting a positive, solid group of friends and community that you could kind of run with and, you know, made that change in your life? Was it something tragic that happened, or difficult, like a car accident or losing somebody you love that like was a wake-up call for you? Or was it just timing? Everything was just the right time. You just had enough. I'll give folks a few minutes.
You don't have running out of places to live.
Yeah, okay. Yeah, I tried to think of a lot, you know, it's not an exhaustive list, you know. Let's see. So a lot of people said wake up call, just the right time. About a quarter of you was either going to treatment or getting arrested or going to jail or prison, right? Which again, all kind of might tie into, there's overlap, right? It's not just one thing necessarily, but so interesting. The wake up call event seems to be like far and away. So, that signifies to me that timing is a part of this, right? Sometimes, whatever we do in our systems, like that's information as we think about having something available to help somebody right then. When that, I think of it as like a window of willingness to like do something different in your life, right? Okay. So now we're gonna go to the next poll. And this question is, what sustains you or the person that you're thinking of, even if it's somebody that you lost, if they had, a time when they were kind of doing well and thriving on your recovery journey? What was, the time that you were doing really well? What was it that really, made a difference? Okay, we'll give folks a minute. All right, so, this is really interesting. 75% of you say a sense of purpose. Now, who can think of a strong federal law that facilitates that? Anybody? I can't. State law, is there a funding stream for that? So interesting. I have like an allergy, so that's what this is. I'm not crying. And then a strong support system. What about a law or funding stream for, to support that? Well, there is some of that starting, right, with like recovery community organizations and peer support, but like, is that baked into, is this purpose and community, which is, what that is, baked into how we think about designing law and policy? I've not really seen that much, right? Maybe we're starting, but not really, right? And then we have family, having children or family, often it's an afterthought. Work, having a home, so medication, if you can scroll down a little bit, we got medication, ongoing treatment at 5%. So that's interesting. When I think about what the bulk of our kind of public policy and law and support is around, well, it is about treatment. But when we think about, what sustains people over the long haul, well, that's just kind of like a time in somebody's life. Also ongoing court involvement, litigation, probation or parole, that's at the very bottom. I see that's not really something that sustains somebody long-term. Well, that's really interesting, right? And, obviously the people in here are not like totally representative of every single person, like, who's struggled with this, but it just kind of is a little bit of a, information, right? And I think what it's showing us is that, number one, people have a different road, different things that really like a different things that help people on their path. And also that it's not just one thing. And that it might not always be the thing that we focus on in policymaking, right? All right, so back to our slides. So today we're going to cover a few different things. We're going to, we talk about defining recovery, which we've already kind of begun doing, right? And also kind of putting it into context. We're going to have a discussion of how the law can impact or support somebody's recovery or hinder or be unsupportive of somebody's recovery journey. We're going to discuss some, oh, I'm supposed to be doing this. Okay. Our technical, there we go. Okay. We're going to discuss some of the legal approaches to addressing the collateral consequences of addiction. We're going to drill down into some specific case studies, and then we'll talk about client representation and ethical considerations for lawyers, but it also applies to advocates, when you're supporting somebody, or even when you're making policy, thinking about engaging people in this, in this work. Go to the next, please. Okay. So an important point to remember up here, we talk a lot in this space about, very tragic circumstances, the numbers and percentages that describe this overdose epidemic that we're in. We talk a lot about barriers to getting help and stigma and lack of access to treatment, about all the things we need to do to fix the system. But, despite all of these challenges, of which there are many, recovery still happens. Recovery still happens despite these systemic kind of barriers and difficulties. I don't think I have to ask here how many people are in recovery or know or love someone in recovery. I think probably mostly everybody would raise your hand, We're everywhere, right? We're living our lives quietly. We're living our lives out loud. This is like the message of hope that I want us to keep in mind, not just like in this presentation, but as we go through the day and as you go out through your work, that recovery is real. It happens. It's very common. And we can measure it. We don't just have anecdotes, we actually can measure recovery. Let's go to the next slide. We saw this, a little preview of this data yesterday, but I'm going to drill into it a bit. National data suggests that most people who experience a substance use problem go on to live in recovery. We saw, Dr. Einstein talked about these data, but let's kind of look again, this is from the National Survey on Drug Use and Health, of roughly 30 million people who at some point perceived they had a substance use problem. About 73%, that's about 22 to 23 million, people consider themselves in recovery or have recovered. What this really means is that recovery is already all around us. And I say recovery, obviously we're going to talk about definitions and this and that, but it's, people who have struggled and now are feeling that things are more back on track, whether they've stopped using or it's not chaotic anymore. The law and policy question, right, is not whether recovery exists. It's whether we can build legal frameworks and systems to be even more supportive of it. Data shows that people have multiple pathways to recovery. Many people recover outside of formal treatment. And just as we saw from the room, treatment alone is rarely the whole story. It's actually not really most of the story. Thought I had somewhere in here, but 22 to 23 million people, that's like the population of Florida. I mean, that is a lot of people who have been through it, So let's go to the next slide. When we often this kind of, what do we, when I talk with policymakers, or even when I was working in state government, people did not always know what I was talking about when I talk about recovery. We don't mean treatment. And we don't necessarily mean after treatment, right? It's not linear. It's not a service. It's not a program. It's a process with many different pathways and iterations. And there have been many definitions, many disagreements, about how to define recovery. I've seen entire summits totally derailed by this conversation, and I have no intention of derailing us today. If we go to the next slide, I'm going to put up SAMHSA's definition of recovery, which I actually I like this a lot. And I think it's pretty much a consensus definition that has withstood the test of time. People with a range of lived experience and expertise came together to develop it. Then they came back together and they're like, yeah, let's keep it. So, I actually really like this process of change through which individuals improve their health and wellness, live a self-directed life, and strive to reach their full potential. So we're going to do questions at the end. And I really like this definition too, because success in recovery isn't just defined only by substance-related outcomes or substance use outcomes. It's defined by stability, by safety, by connection, by quality of life. I love this, self-directed life kind of concept. Let's go to the next slide. Dr. John Kelly's research was mentioned yesterday, so here it is again. People use a variety of supports to make their way to resolving a substance use problem. Mutual support is the biggest. It's almost half. Treatment, 28%, right? So again, kind of to put this in context. And then other supports, whether it's faith communities or family or something like that. And of course, people have varied, my journey involved all of these things, right? All right, next slide, please. But treatment, as we talked about, is like really outsized in the policy discussion. And in the regulatory context as well, and in the funding context. And it's really only the tip of the iceberg. The ocean underneath is building a life. Next slide. So I think, our systems, though, are not really built with this in mind. They're largely built around crisis response and acute response, short-term stabilization, not long-term like being a person in the world, and the goal of helping people rebuild their lives or facilitating that process of life rebuilding. Actually was going to look this up and totally forgot until now. There was a survey of the opioid settlement funds and what they're being used for, and recovery was. But do you know that the answer to that, Kristen, off the top of your head?
Pretty low.
Pretty low, right? It's just interesting, right? In saving lives the moment they need saving, I'm not going to ever sit up here and say we shouldn't do that. Much of our work at O'Neill, that's what we're focused on. With naloxone or medication or treatment, it's all like, incredibly critical and important, and has brought overdose death numbers down. But like, then what, right? Our systems are not really designed to answer that question. I think often about, so I lived in my husband was stationed at Fort Bragg, and I lived in North Carolina for like 3 years, which I loved it, by the way. And I think often about this like residential treatment house, I don't know what you want to call it, that women were living in, rural North Carolina. Every woman there was on buprenorphine, everybody there. Everyone had a child living with her and a child that she had lost custody of. Most of all of them had like a domestic violence history, history of incarceration. They didn't have anywhere to go, like kind of quote unquote last house on the block, literally. Came from difficult family situations, would go back to difficult family situations. And they had these little hometowns scattered around North Carolina with like very little support system. They were all on buprenorphine. Okay, but then what? Right, but then what? Our systems are not set up to answer that question right now. You does not treat trauma. Okay. Yes, of course, medication can stabilize somebody physically, your brain and your body, but it cannot by itself kind of put someone's life back together. I think a lot about a friend I have, and I told the story to Jeff back there, who wanted to start an NA meeting on Fort Bragg, at Fort Bragg. And he was told, this is the largest Army base in the country by population, by the way. Statistically, probably could be a good thing there. And he was told, no, you can't do that here because soldiers don't do drugs. This was while at the same time there were a series of pretty scathing articles in national news. I don't know if people remember this, about murders at Fort Bragg that were drug-related murders.
Out of curiosity, are there AA groups at Fort Bragg?
They weren't allowed to do an AA group,
They were, okay.
but not NA.
But on it.
Yeah. National news, active duty soldiers involve murders, okay, drug related, but can't start a support meeting, okay? Systems are just not set up that way. So, what might we need, looking at this, I like this graphic. What does the research tell us? Well, there's some research. There actually is some, hopefully there will start to be more. There's actually great, some really great funding right now for some really interesting recovery related research. And there's a conference coming up, which I've been to a few different times, and it's like really interesting. So the research tells us, stable place to live, meaningful work, education opportunities, social belonging, what people in here said, feeling like you're part of a, being someone in the world, right? Peer connection, safe place to get healthcare, mental health support, the ability to just participate in life without, 1,000 indignities a day. Connection, stability, opportunity. And what does that look like? I think, what does that look like? Right? Maybe making it easier to get help than it is to get high. People, I think, often return to use when systems force instability. It's already hard enough, and I think about like stories that I've seen over the years, like a guy who was employed, had his kids back, but still had to go to jail every weekend for a year. Every weekend for a year. Why? Why? The person who's kicked out of her sober living residence or recovery residence for having a recurrence of use with no connection to any other level of care. So she went back to live with her mom, who used with her and lost her life, right? She was kicked out for 30 days. Is there a clinical reason for that? 30 days, Dr. Olson? No?
Zero.
Just the way it's always been done, so we better keep doing it. The woman who had to report to jail after being in recovery for 2 years, stable on methadone, and the jail didn't provide methadone. What are we doing? Right? The person who has finished almost 2 years of drug court, which, thinking about how onerous that is, this person that I'm thinking of did not have a car or couldn't drive. He had a car, but he wasn't allowed to drive it because it was DUI related. And one day misses court because of a transportation issue. What do we think happened to him? Go to jail. Almost 2 years of these things happen every single day. Every single day. The mom who gets CPS called on her after giving birth on medication for opioid use disorder. She's in treatment, right? It's very stressful to have CPS involved in your life. Very stressful and shameful, It's already hard enough. It's already hard enough. And, recovery helps us to be a person in the world. And often policy blocks our ability to do that. And it's already so hard to just exist sometimes. So the law or how it's implemented can either stabilize, be a stabilizing force for somebody's journey, or destabilize. So this list under the iceberg here, these all contain policy opportunities to support people on their journey, like removing blanket exclusions based on criminal history for things like housing, employment, education opportunities, civic participation, or investing in peer support to support people longer term on their journeys, not just for, the moments that they're engaged in treatment. Why don't we do this already? Well, I think this reflects a reality that Structural stigma and discrimination are often embedded in policy. It's hard to legislate compassion. It's hard to stop the inertia of the way things have always been done. And even I think when policymakers mean well, and I've sat in a lot of rooms, people who are living these barriers or have lived them are rarely consulted or included in the conversation. Even if they are, it's like as an afterthought, not at the beginning when you're like designing the change. And also, recovery is not a linear journey. People almost never go neatly from harm reduction to treatment to, recovery. Yet that's how our systems, think of substance use disorder in this continuum, but it's not really like that in reality. And our policy and legal systems are not really built for someone with like a non-linear human experience. The other thing I want to say about these items under this iceberg and more is that these are all pretty much completely siloed systems that don't have the same goals, that don't have the same funding, that don't align. You have people maybe working in the same building on these issues that have never met each other. So operationalizing ecosystem type models like recovery-oriented systems of care, recovery-ready communities in Kentucky, inclusive recovery communities, evaluating those models for whether they could be effective. There's been some, good work started. Is it working? Do we need to tweak it? Should we fund it? Should we evaluate it? Probably. Connecting all these pieces together and then measuring true outcomes, not just process. True outcomes. And so some of this work has really started in cities and counties and states across the country, but it's very slow going. All right, so let's go to the next slide. So everything we've talked about so far is kind of systems level, but recovery is lived on the individual level, daily decisions, daily stability, daily access to opportunity, daily, get up every morning and we're doing it again. And, just like we talk about social determinants of health, there are also legal determinants of recovery. The laws and policies and legal processes that shape whether someone's, that can help someone have some stability or, knock somebody off track. And for many people in recovery, the law shows up every day, whether it's housing eligibility, child custody, background check when you're getting a job, access to medication that you need to sustain, stability, insurance coverage, the consequences of having a criminal record. Can you rent an Airbnb today? Talking about that. Probation, parole, all these things, and so for many people, their recovery is negotiated through these legal systems. The same law can either stabilize or destabilize, depending on how it's applied. The ADA, Americans with Disabilities Act, can protect or can be ignored. Medication for opioid use disorder access, either you can get it or you don't get it. Where it's blocked, you can have your records relief or not, housing protection or discrimination, right? Legal problems also rarely happen one at a time. Housing instability leads to employment instability. Employment instability leads to family instability. Family instability, this is all kind of heightens your risk of being kind of thrown off track. And things can really snowball quickly. That's why legal representation and legal advocacy are really recovery supports, even when we don't always call them that. All right, let's get to the next slide, and then I'm going to turn it over to my co-presenter. So when we talk about legal determinants of recovery, they tend to show up across four major kind of legal arenas: status and rights. This is about whether the law recognizes you as a person with protections, access to healthcare, housing, disability discrimination protection, the ability to parent. Then you have surveillance and punishment. That's where recovery intersects with criminal legal supervision, probation, parole, drug testing, incarceration, access to medication inside systems, things like that. Collateral consequences are the barriers that follow people long after the criminal case ends. A decade, 2 decades, you know, into their housing, employment, licensing, their education. And then family regulation is where recovery intersects with child welfare and family court systems. So that's child custody, CPS involvement, pregnancy-related reporting, things like that. Many people will touch more than one of these arenas on their journey, often at the same time, right? So now I'm going to turn it over to my co-presenter, Sazula, to talk about what this actually looks like in real people's lives and discuss the role of attorneys and advocates in supporting people.
Thank you, Shelley. So just a quick note, I'm noted here as representing Faces and Voices of Recovery. I do contracting work for them. I'm an adjunct faculty member, but I'm not here representing them. I'm here as a solo attorney, representing myself and the work I've done, just to clarify that. So if we could have the next slide, please. So this slide is actually a screenshot of the collateral consequences inventory, national inventory of collateral consequences of conviction. There are more than 44,000 as of October 2024, state and federal collateral consequences. And it affects at least 70 to 100 million people nationwide, these collateral consequences. And so let's talk a little bit about what collateral consequences. Next slide, please. So I'm a big proponent of talking to you, and this, I'm not going to read the slides, right? You can read the slides and I'll talk to you and provide extra information. So for what are collateral consequences? I think the simplest way to explain it is in a military situation. If there's a strike on a building because there's intel that says there's enemy combatants there, but they're wrong. And so a whole bunch of innocent people die in that strike. That's collateral damage. And so collateral consequences are a very similar thing in the realm of criminal convictions and recovery. So it's a side effect that's not directly intended by the primary policy or the primary action. Now, of course, some of these represent a legitimate purpose. Someone who's been convicted of child sexual abuse or a violent crime, it makes sense to prevent them from having a firearm, right? And in addition, people who have committed crimes of, financial crimes or fraud, keeping them out of positions of public trust. I was actually researching some of the collateral consequences, and there are some crazy ones out there. In Virginia, any criminal conviction prevents you from working or volunteering at the Animal Humane Society indefinitely. I mean, it's just insane. I mean, what on earth could that, where's the nexus between that and an offense? Other collateral consequences are directly related to a particular crime. I think the most in the interest of public safety. So one of the most obvious examples is for someone who's convicted of driving while intoxicated or under the influence, it makes sense to revoke or temporarily suspend their license in order to protect public safety. The problem is that these collateral consequences often apply without regard to the relationship between the offense and the opportunity, as I mentioned with the Humane Society. And also without consideration of the time passed or the person's efforts at rehabilitation since the conviction. And so these can be, permanent. Sometimes they're called permanent punishments that can just be imposed on people for having a criminal conviction for life, for things that have nothing to do with the offense they committed. So let's go to the, actually, next slide and then the following slide, please. So I'm going to talk about 3 legal remedies. And as Shelley was saying, believe me, I spent time in federal prison. I've been on methadone. I've got the bona fides. I don't want to go into those right now. That's the focus, not the focus of this. And I'm happy to talk about. I'm an open book about all of that. So what is expungement? So expungement is a legal process that seals the criminal records for someone. Now, expungement and sealing records is slightly different. So expungement removes the information from the public domain. And my primary practice in Minnesota, from 2015 to 2020 and continuing today, has been expungements. And so, the benefit of an expungement is that in 2015 in Minnesota, there was a law enacted, statutory expungement. Prior to that, it was very nebulous. Basically, if you had an offense you wanted expunged, you appealed to the court and they had what's called inherent authority. They got to decide based on their, opinions and feelings whether or not you deserved it. The statute creates very specific, 12 factors that the court has to consider. And there are, of course, waiting periods. Again, in the interest of time, I don't want to go over all of the different, petty misdemeanors, gross misdemeanors, felonies. Happy to do that after, or if someone has a question during the question period. So expungement completely destroys or seals the records. And the importance of this is that this statute in Minnesota in 2015 gave the judiciary the power, the authority to order the executive branch, the police, the Bureau of Criminal Apprehension, which is the database for all criminal history records. They have the authority to instruct them to destroy or seal all records. Now, of course, there are exceptions. For instance, if someone is convicted of a DWI and then they have another offense within 10 years, the executive branch, the police can ask for a court order to open the records in order to use that first conviction for enhancement purposes. So to impose greater punishment for a second offense. Sealing access to records does not necessarily remove them from the public domain. And most importantly, it oftentimes, the records are still available to background check companies, the police, the public, et cetera. It's not a complete remedy. And so they're not exactly interchangeable. So eligibility, generally, the easy ones apply to if you've been acquitted or there was a stay-in position, you were judged to be guilty, but the sentence was stayed. You completed the terms of the diversion or whatever that might be. And then at the end of that period, the conviction is dismissed. And so those kind of things are basically, you don't need, prosecution approval. You can just apply for a petition and those are a given. The other eligibility is in Minnesota, misdemeanors, gross misdemeanors, and there's an enumerated list in the statute of 50 specific felonies. One of which is rustling cattle. One of which is changing altering a livestock certificate. I mean, just some of the most absurd things. And so the legal process requires filing a petition with a court. It's very due process heavy, which means that there 60 days prior, you schedule the hearing, and then 60 days prior to that, you serve the petition on any possible agency, the police, the prosecution, the Department of Natural Resources, any agency that may have a record that my client thinks at some point, maybe they might want to go into nursing eventually. We serve the nursing board. Because by serving them and giving them a 60-day period to object, if they don't object, they've waived that objection. So once that 60-day period is passed, the hearing is held. And the judge reviews these 12 factors, the time since the offense, rehabilitation efforts, et cetera. And the presumption in the law and the statute is that as long as these 12 factors are met and the petitioner, the person asking for the expungement, can prove by clear and convincing evidence, which is one of the burdens of proof. We're all familiar with criminal, which is beyond a reasonable doubt. And then the lower one, which is preponderance of the evidence, more likely than not. Clear and convincing evidence is not explicitly definitely explained, but it's generally about 75%. You know, the evidence presented makes it 75% at least likely that the evidence proves the facts that are being alleged. And so once the judge has done this, and whether they grant or deny the petition, then there's another 60 days to allow whichever party didn't win to appeal. And so then after that 60 days, if there are no objections or appeals, that's when the final expungement order goes into effect. And the ultimate deciding factor is whether the benefit to the petitioner of expunging these records and sealing them and, you know, freeing these people from these, you know, criminal record history records that people use to, you know, deny employment, deny housing, as Shelley mentioned, Airbnb, you know, just things you wouldn't even think about. And so whether the benefit to the petitioner outweighs the burden on the courts to enforce the expungement order, because they have to serve it on all the agencies, they have to ensure that the agencies respond and send the petitioner, you know, confirmation that they received the order and they have destroyed the records. And then also, so the benefit outweighs the risk to public safety, essentially. See what slide we're on here. So I'm going to talk about expungement and do case studies. The second one that I'm going to do, actually, if you could just go back one real quick. So the Department of Health and Human Services set-asides. So there's a line in the Narcotics Anonymous literature that's fairly well known, which is that the therapeutic value of one addict helping another is without parallel. And we have seen this with the proliferation of peer support services, right? People who have been through it, who are experientially credentialed, have a unique way to support people seeking recovery. And so, so essentially, when someone wants to work in a facility, an inpatient residential facility that is licensed by the Department of Human Services, a background check is required. Now, oddly enough, the person can start working at the facility, and then the facility submits the request for a background check. So the person's already started the job.
Okay.
And then pretty much any criminal conviction results in a disqualification due to the background study. And so at that point, there is a reconsideration of the disqualification process and appeal process. Very similar factors, such as, you know, the time since the offense, rehabilitation, and again, is this person going to be a threat to public safety? And in particular, the vulnerable adults that they serve, because vulnerable adults in Minnesota are defined by law, statute, and included in that is people with substance use disorder in a residential facility or an inpatient facility. So, get to my my next thing here. And then finally, I'm going to talk about pardon extraordinary. So of course we know about presidential pardons. I applied in 2015. I'm still waiting. I made it all the way through the FBI 3-hour interrogation. 2 FBI agents followed me without my knowledge for 2 weeks. Asked my neighbors, does she pick up after her dog? What time does she come in at night? I mean, it was intense. And ultimately, I was told that I passed muster and my petition was sent to the pardon, people who handle pardons in Washington, DC. And this is 2015, right? Kind of the transition between the Obama administration and the Trump administration. And I did not receive a pardon yet. It's still pending. But a pardon extraordinary is a state remedy. And unlike expungement, it's also called executive clemency. This does not seal the records. It does not hide them from public view, but what it does is it signifies that the state has formally forgiven the person for their behavior. It doesn't say it didn't happen. It doesn't hide it. The Bureau of Criminal Apprehension, the executive branch, is required, even though they don't have to seal the record, they have to add a note in that criminal history record saying a pardon has been granted. So it essentially restores the rights of individuals that have been denied due to a criminal history. So next slide, please. So talking about expungement, just a little case study. So Alex, who was a graduating senior in a collegiate recovery program, had substance use issues as a juvenile, and he committed basically 3 misdemeanor offenses. Twice he walked down the street in his neighborhood, checked for cars that had open doors, and stole valuable things. Of less than $5,000 total value. And then as an adult, he found a car that was not only unlocked, but the keys were in it. So he decided to take it for a little joyride, only made it about a block, drove up onto the curb, and then was terrified, ran, and was eventually apprehended by the police. And so this was an excellent of the new 2015 statutory expungement process. So juvenile records are automatically sealed, 2 years after someone becomes, reaches the age of majority. And so in his case, he just consistently, with every single time he applied for housing or employment or, try to stay in Airbnb, he would receive a rejection, often accompanied by the background study that had been conducted by an agency explaining why. And so one of the other beautiful things about the Minnesota statutory expungement is that it requires, once the expungement is formally granted, it requires any of those databases, those private background study organizations, landlords, employers, it requires them to, if they have a record of it, they have to destroy it and they can't use it against the person. So he was able to get a job, he was able to get a place to live, he's thriving. And then I just want to add, in Minnesota, they have the statutory expungement, again, where it's very clearly laid out, proved by clear and convincing evidence, benefit to the petitioner outweighs the risk to public safety, the 12 factors are considered. But there's also something called inherent authority. So I believe I already mentioned, there are 50 specific felonies enumerated in the statute that are eligible, like rustling and changing a livestock certificate. And if a felony that you've been convicted of is not in that list, then it's not eligible for expungement. Under the statute, however, it is eligible for expungement under what's called inherent authority, inherent judicial authority. The problem with that is that the judiciary has no authority in that circumstance to direct the executive branch, the police, the BCA, et cetera, to destroy their records. They can only control the court records. And what really matters is those executive branch records that, are the feeders for the background check companies, and most often results in denial of employment, housing, et cetera. And then just one final note. So actually in 2025, January 1st, Minnesota enacted the Clean Slate Law, which offers automatic expungement for people who are eligible. The problem is that the impetus or the people who have to initiate the process are the people at the Bureau of Criminal Apprehension, the executive branch. And there's no enforcement and no incentive for them to do so. So, and there's also severe issues with notice. They might find an expungible offense, but whether they notify the person, we don't know, and let's just say it's not a top priority. So that's another avenue that can be helpful. However, that does not seal the judicial records. And so you still have to file a petition to seal the judicial records, which, like I've said, are not as critical in terms of all these collateral consequences as the executive branch records. But it's a hopeful sign. Next slide, please. So talking about employment disqualifications is when I talked about the Department of Human Services background disqualification due to criminal background or criminal history background. And so anyone wanting to work in a licensed facility, of course, has to undergo this background study. They're almost any offense basically disqualifies them. And then the process of applying for a set aside, asking for reconsideration occurs. And these are all based on the same factors, the time since the offense, the rehabilitation efforts, the, letters of recommendation, the role in the community, et cetera. And if the person can prove that they've been rehabilitated, they're not a threat to public safety, then what's granted is called a set aside. So they set aside the disqualification and allow the person to work in those facilities. The practice used to be that every single time someone moved to a different facility, they had to go through a new background check. They were disqualified, even though they had already cleared that and gotten a set aside, and had to go through that process over and over. Now, thankfully, the process, once you've been granted a set aside, is as long as there's no new criminal conduct, it applies to all employment within the DHS field. So, Ken, big guy covered in tattoos. I mean, I actually met him I'm also a yoga teacher, met him in my yoga class. And he's an ideal candidate for helping people because he was willing to work in some of the rougher facilities. And he had the experience to talk to people who've been through it and to help them. Peer support, mentoring, et cetera. And so his convictions were in a different state. He had been convicted of manufacturing meth less than 3 grams. And then it was 2002. And then in Minnesota, he was convicted of possession of a small amount of methamphetamine, 2013. And so, he served prison time, fulfilled his sentence, and then began pursuing recovery and rehabilitation and all these things. And once he got the disqualification, we applied for reconsideration. He was granted a set aside, and he's known throughout Minneapolis and St. Paul as being a resource for kind of the hardest cases because, he comes into the room and you're like, whoa, just to be frank. So next slide, please. So I talked about the pardon extraordinary. So my client, Rita, person in recovery, mother of a young child with autism. She, she was denied employment and advancement. And the thing that was most egregious to me was that she wanted to participate in her son's education by chaperoning, by volunteering in the classroom, et cetera. And she asked the superintendent, and he said, absolutely not, based on your criminal history record. And so she hired me and I said, okay, well, what's the appeal process? He said, there is no appeal process. This is a final decision, which makes my little lawyer heart go, no, no, no. So, she had actually tried twice before to apply for a pardon extraordinary. Thankfully, in between her second denial, which it requires 5 years wait between each attempt or each application, the process was changed. So it originally was, the Board of Pardons was the governor, the attorney general, and the chief justice of the Supreme Court. And it required unanimous agreement that the pardon should be granted. They changed it, so they created a commission of people who first vet the applications, and as long as a majority of them agree that it should be sent on to the Board of Pardons, those 3 individuals, it is sent to them. And it's no longer a unanimous requirement. So as long as 2 of the 3 agree, it's granted. And so her pardon was granted. And again, this doesn't erase the record. It's still visible to the public. There is a note that says this has been pardoned, she's forgiven. And she is now able, whether that superintendent likes it or not, to chaperone her son, who again has autism, has some sensory, I mean, it's a real strength to have her in the classroom, chaperoning on field trips, et cetera. And for her to participate in her child's education. So next slide, please. Okay, 5 minutes. All right, so I'm gonna rip through the rest of this. I covered what I believe is the most important stuff. So next slide, please. So I believe that there are 5 fundamental competencies for working as an attorney or any support professional for someone with substance use disorder. Understanding substance use disorder, I'm not gonna go over that. Presenters yesterday talked about evidence-based treatment and the causes, trauma, genetics, epigenetics, et cetera. It is a matter of competence, which is a requirement for attorneys that they have this information when they're working with people with substance use disorder. Second, knowing your client's substance use disorder related experience. I'll just tell a brief, I know I have 5 minutes, but when I was facing charges for conspiracy for sending drugs through the mail in 2005, my attorney and I were at lunch prior to a hearing, and I was explaining to him how, I found that I was using methamphetamine, it helped me with some of my depression, and I was trying to explain why I was using these substances. And he said to me, you know what? You're not gonna change. You're a junkie. Nothing, you're gonna be dead within a year. This is my lawyer, representing me. And so, it was just, how demoralizing, right? And so it's critical that lawyers explain the duty of attorney-client privilege, confidentiality, as well as the limited instances where an attorney is allowed to go outside of that. For that briefly in a moment. Explaining the interplay of substance use disorder with legal representation. So if anyone is familiar with immigration law, if someone is convicted of a crime of moral turpitude, they can be deported. And so it is essential that the lawyer explain that to the individual, the client, prior to them making a decision whether to plead, et cetera. And it's the same thing. The attorney needs to explain not only the legal consequences of returning to use, being ejected from a treatment court, but also the collateral consequences, family regulation system involvement, loss of custody, termination of parental rights, et cetera. And explaining all of those things so that someone has all of the information, which can help them with returning to use. For representation needs and barriers, I'm hurrying as fast as I can. This is something that doesn't normally happen with a client that doesn't have substance use disorder or mental illness and who can, afford to pay me. But it's critical to say, do you have transportation? Do you have access to the internet? Do you have a cell phone? Do you have, obligations like treatment or having to go get your methadone or whatever it might be that would interfere with your ability to attend court appearances? Because having that knowledge makes it possible for the attorney to deal with those and explain to the court so that the person doesn't get in trouble. And then finally, knowing the resources available. And these are not just treatment or mental health treatment. These are also, housing resources, clothing, community supported RCOs, peer support, et cetera. It's not that the lawyer has to explain these and then drive the person there and everything, but they have to be knowledgeable about them and be able to discuss them with the client. Next slide, please. And so just super briefly, attorneys have ethical obligations specific to working with clients with substance use disorder. I'll just say the bottom line is that, unless the attorney has a reasonable belief that the person is using and they are at substantial risk of serious physical harm or death, that is the only instance when they're not required to break client confidentiality and involve a third party. Because there's a presumption of competence, right? Even people with substance use disorder are presumed competent. And so attorneys have to abide by their wishes. And next slide, please. There are also some, next slide as well. So there are state ethics opinions that reinforce this. Excuse me. Basically, unless the person's capacity is so diminished that they're unable to represent their own interests, and there's this reasonable belief that there's a substantial risk of harm or death, that's the only time when there's the possibility that they can break client confidentiality. So I believe that's it for me. Thank you so much for listening. Thank you.
Information. Thank you so much. We have about 5 or 6 minutes for questions. Gina says 5. Nikki.
I have a question about, well, thank you both very much. I have a question about the, I think it was the CLEAR legislation that passed that you were talking about. How many people have gone through the process to actually?
Oh, the clean slate?
The clean slate.
Full candor, I don't know.
Yeah,
It's not exactly an up and running and successful program yet.
Who spearheaded that?
It was a legislative, it's a law.
Right.
So basically, and Minnesota, in my experience and opinion, is very forward thinking and is very interested in giving people second chances. I don't know if people are familiar with ban the box, where on an application, there's a check, have you ever been convicted of a crime? Minnesota has made it so that you can't ask that on an application. You can only ask about those things once an interview has been offered or a job offer has been extended. So Minnesota's doing a lot to provide second chances.
Cody had a question.
Oh, yeah, related to that, I was, if I understood you correctly, can people who are eligible for expungement initiate the process with BCA? Or?
That's an excellent question. Certainly they can. There's no guarantee, there's no guarantee the BCA will jump up and say, oh, of course, let's handle it. But yes, the people have the ability to contact the BCA and say, under the Clean Slate Act, I want to know if my offense is expungible. And then again, as I mentioned, they also need to file a petition to get the court, the judiciary records expunged, as well as the executive. So yes, they are able to reach out and request that. Yeah.
So this might be kind of a dumb question, but if so many people lose voting rights, housing rights, etc., because they're convicted criminally, how come a 34-count convicted felon is the president? Like, how does that work?
Okay, so I have very strong opinions about our current administration, and so I'm gonna leave that alone, frankly. You know, yeah, it's an excellent question. We can talk privately. I don't feel comfortable discussing my own personal opinions.
And then, it's like, could a president pardon himself?
You know, that's up for debate. I mean, common sense would say no, right? You know, I can commit any crimes I want and just pardon myself. However, there's no precedent or no history to dictate or no case law or anything that explains whether or not that can happen. So I'm sure we will see.
I'm sure we'll find out.
Yeah. But those are both excellent questions.
Any other? All right.
So I want to be careful not to slander the entire profession because I have been a licensed lawyer for 50 years.
All right.
But in my experience now, I'm in government now. And so I think that a lot of our, number one in Maine, we don't have enough lawyers. People don't like to hear that opinion, but we don't.
We have plenty
We,
here.
we particularly, we got a lot, and at one time, most of the lawyers were in Washington DC and Portland, Maine. But up in the rural parts of the state, there's just no lawyers. So the law, we have a tiny law school. But the Chief Justice of the Supreme Court, the former Chief Justice, now the Dean of the Law School, and she's fantastic. So so they already have a clinic up in northern Maine where it's helping. But my point was going to be, our defense attorneys, appointed counsel particularly, they do not understand the collateral consequences of these convictions. And that's a huge problem. I mean, we can do CLE, but I don't know whether that's been your experience as well, that, you know, they get the person to plea, they've got 50 cases that morning and going through the docket, and the person in recovery doesn't understand that they can't rent an Airbnb.
Right.
Housing, employment, everything, family service. So is this a problem elsewhere? Because it's a problem that we have.
Absolutely. In general, I do continuing legal education on this and other issues. And people aren't interested because frequently people are not, you know, don't have the financial means to pay a lot of money to have this done. I personally, because of my experience, this is my passion. I mean, it's an essential part of helping people reclaim their lives. And part of my mission is to educate people, especially, you know, it varies by jurisdiction, but most jurisdictions have some sort of statute or process for expunging criminal history records. Notice I say criminal history records as opposed to criminal records, because just adding that word history creates some space. So people are kind of like, oh, it's in the past. Yeah, there's definitely a dearth of attorneys who are willing to take these things on. Absolutely.
I'll say also, you know, it brings up a few issues. One, kind of like what Sazula talked about, the gap between, well, here's what the law and policy is, but implementation is everything, right? So even if there is a great law on the books, it's really about prioritizing it, funding it. You know, and I think what we see in a lot of cases where we're trying to kind of move the culture, a culture change is really what it is, well, this is just how we do it now. We talk to our clients in this way. It starts with leadership, I think, at the top. So like in Indiana, for example, Chief Justice Rush of the Supreme Court was just on fire about making sure that judges and attorneys in the state understood medications for opioid use disorder. I mean, she was on it, right? And so it helped to shift the culture. I think somebody like the former Chief Justice, who's the Dean of the Law School, can use that platform. And it's also about educating judges as well. I think, you know, just they can participate in that process too. It doesn't have to just come from the defense attorney. But it's tough. It's tough to shift culture.
One quick thing I'd like to add. So one of the values of having these core competencies and really getting to understand and know your client and their relationship with substances and, you know, treatment and what they want, is that you can use that at sentencing as mitigation evidence. To say this person experienced this trauma as a child, because there's always a reason people use substances. They may start innocently, but once they use them habitually, that's the solution for whatever underlying issue there is. I may have mentioned this, but I saw a TV show recently with a great line where it says, in order to recover, you need to know what you're recovering from. And we are responsible for educating judges. There's tremendous ignorance and stigma. So thanks for your question.
Our treatment and recovery court have done a big, that group, and there's an advisory committee there. Our judges that are doing those courts and the defense attorneys and the ICMs, I mean, honestly, fantastic, saving lives.
Awesome. Yep, I did defense in a co-occurring court, essentially,
Yep.
a mental health court for a few years.
All right, thank you, everybody.
Well, thanks very much. I'm going to introduce Professor Talid El-Sabawy, who is a professor at Wayne State in law, but she also teaches in our Master of Science in Addiction Policy and Practice program. She teaches the history of addiction, basically, which is one of our first semester classes. It is the only remote. It's during the only remote seminar, so a lot of our students won't have the opportunity to meet Professor El-Sabawy in person, which is a disappointment. Have we got her on? Is there a way to, okay, all right. Professor El-Sabawy is at Wayne State. She also is a research scholar at the O'Neill Institute. We've done quite a bit of work with her, a lot of writings on treatment in carceral settings, as well as deaths in carceral settings. She holds a JD and PhD in public health, health services, management, and policy. And her work focuses on the narrative discourse surrounding opioid overdose death and health insurance parity. She also does a lot of really interesting work in North Carolina on harm reduction programs that perhaps she'll talk about today, but perhaps not. And then Professor Matthew Lawrence is professor of law at Emory University. And, there's a lot of really big brains in this field, many of whom we're having speak today. I consider Professor Lawrence one of those. And the thing is that what distinguishes him from another professor is that he was an advisor to the Drug Enforcement Administration. So he really knows the ins and outs, as well as kind of it's not just what it should be, but how things can happen or not happen, as the case may be. He's worked, for DEA, advised the House Budget Committee and the Office of Management and Budget. So please join me in welcoming Professor El-Sabawy and Professor Lawrence, and I will leave it to Professor El-Sabawy to start.
All right. Thank you all for having me today. And sorry I couldn't be there in person. I encountered some black ice and sprained my ankle. So really apologize if any of the students are there. I was really looking forward to meeting you all in person, but it is what it is. So thank you, Regina, for the wonderful introduction. Yes, I do work in North Carolina with some of the harm reduction groups out there. We started a housing program embedded in a syringe service program, as well as we have a study ongoing looking at drug-induced homicide charges in that area. So, but none of that is what I'm going to be talking about today. Today, we're going to be talking a little bit about why the DEA, not the FDA, and we're kind of going to revisit the regulation of potentially addictive substances. So for decades, you all are aware, right? We have the federal response to drug use dominated by criminal justice thinking. And though in more recent years, the response to the opioid crisis has seen a shift in tone, and even Congress has admitted that, hey, we need a little bit more of a responsible public health approach here. The federal agency that retains primary regulatory authority over the classification and availability of what are deemed potentially addictive substances is not a health agency. It's the Drug Enforcement Agency, a criminal justice agency within the Department of Justice. So to me, it begs the question here of why is a law enforcement agency in charge of regulating medicine? How did this even come about? And why wouldn't we have a public health oriented agency with scientific expertise that has long regulated pharmaceuticals also regulate substances that could be potentially addictive? Also, we're going to explore today. How did we end up here? And I think what we're going to see is that this isn't just about statutory interpretation or bureaucratic inertia. There's some deep institutional history here. And what you're going to notice is that the DEA ended up with these powers, not because there was a conscious decision that this would be most efficient, most effective, or even the most evidence-based ways to regulate these substances. And I think, this leads us to reframe the question, though, why in 2026 do we still have a criminal justice agency regulating medicine? Before we get to that, before we advocate for policy change, we got to figure out how we got here. So let's start with the first crisis of unregulated medicine. For those of you who are not aware of this history, at the end of the 19th century, the US was flooded with what were termed patent medicines. These were unregulated, secretive formulas. They were sold to unsuspecting publics. And these remedies claimed to treat everything from toothaches to coughs, pneumonia, asthma, right? And many of these tonics were laced with morphine, heroin, cocaine, alcohol, you name it. And the ones I showed you today in these advertisements, they were pretty explicit that they contained cocaine and heroin. But the majority of patent medication did not necessarily advertise that they contained these drugs. At this time, there was no labeling requirements, no dosing requirements, no requirements for warning. And that brought us to the first piece of major federal legislation to regulate drugs, the Pure Food and Drug Act. Now, it was passed in large part due to the jungle, which was about horrific practices in meat packing, right? So we had food and drug regulation. And but it did regulate pharmaceuticals, sort of, right? It required accurate labeling of ingredients and prohibited misbranding and adulteration. It was a very, very narrow exercise of federal authority, and it allowed the government, though, to seize products and to prosecute manufacturers, which was huge, right? It also required manufacturers to disclose the presence and amount of 11 quote unquote dangerous ingredients, which include heroin, cocaine, and alcohol. So enforcement powers were given to the Bureau of Chemistry, and this would eventually become the Food and Drug Administration in 1930. They had two major enforcement mechanisms, right? They could seize the offending material and they could also criminally prosecute. So the FDA did have criminal prosecution powers even this early on. Now, the majority of the enforcement early on was for food adulteration. However, in the 1920s and 30s, we started to see more focus on seizing misbranded and adulterated drugs. And so who did these seizures? Who was responsible for this criminal enforcement? It would be the Food and Drug Inspector, and this is a picture from the 1910s of some early food and drug inspectors inspecting cream. These enforcement officers were not anything like what we would think of when we think of police officers, right? They worked very closely with scientists. They wanted, as part of their job description, their apparel had to be neat, right? They were told not to be menacing, and they focused really here on incorporating scientific inquiry, consumer protection, and a bit of collaborative enforcement. And so this is the early cultural model that the criminal enforcement in the FDA So we have in 1938 an expansion of the FDA's power in the 1938 Food, Drug, and Cosmetic Act. And that was due to, what was called the American Chamber of Horrors. The FDA assembled a large exhibit at this time of legally sold products that were harmful for computers, like for consumers, not computers, sorry, including a little bit before that, including what was called lash lure, which was was sold as, you know, as an eyeliner of sorts and actually caused blindness. And so that, as well as you know, other instances of pharmaceuticals that killed many children, et cetera. We had I'm trying to go quickly through this so that I can finish the presentation. But anyway, we ended up getting FDR to sign the Food, Drug, and Cosmetic Act. Now, the Food, Drug, and Cosmetic Act was an expansion of powers because it required pre-market safety approval for all new drugs. And it banned false therapeutic claims. So it expanded the FDA oversight also into cosmetics and devices. And it gave the agency the power to enforce, of course. Now, again, here we had the FDA inspectors who were the primary on-the-ground enforcers. And so what did they do when they got this expansion of powers? Did they go out and conduct raids? No, much of their work during this era involved conducting surveys, right? So they had inspectors travel around the country gathering data on manufacturing practices, product formulations, sanitations, conditions, not just to catch violations, right? They were trying to understand what was going on in the marketplace. They were trying to figure out how they could educate and prevent and gather scientific evidence. So that was the culture, again, in which the FDA's enforcement practices were based in, at least early on, right? And so there we go. Beginning in the late 1930s, FDA investigators started investigating the illicit distribution of stimulants, amphetamines, and barbiturates. Now, these drugs were legally manufactured, but they were increasingly used off-label or misused or diverted. And so the agency determined that they're not safe for self-medication. And so they began to distinguish really between over-the-counter and prescription drugs here and to target illegal over-the-counter sales. And in 1948, the Supreme Court confirmed the FDA's jurisdiction over retail pharmacies. So that further solidified their power. So between the 50s and the 60s, FDA investigators had more than 2,300 convictions of individuals and firms engaging in illicit drug sales. Right. And they would do this through truck stop works where they would go undercover to buy prescription drugs at pharmacies or truck stops, roadside vendors. So this kind of all set the stage for the creation of the Bureau of Drug Abuse Control, which was housed in the FDA. So the FDA's Bureau of Drug Abuse Control was created through the Drug Abuse Control Amendments. And it did something pretty remarkable for the time, right? It gave FDA investigators the powers over something they were already doing, which was to police illicit over-the-counter sales and to track diversion, but only over non-narcotic substances. And we're going to talk about why and the parallel history that sort of arose in the regulation of narcotic substances. So the Bureau of Drug Abuse Control was granted authority over all potentially addictive non-narcotic drugs. They were given new offices, they were given new funding, they were told to hire new investigators. Not only that, they were given the ability to carry firearms. So now we had FDA investigators carrying firearms, making arrests, serving search warrants. And so we have this moment in history here where the federal government placed responsibility in this public health agency to enforce rather than the criminal justice agency. But that experiment didn't last. And now we're going to kind of pause. So you can think here we're in the 1960s, right? We're going to pause and we're going to go back and look at the parallel history unfolding for narcotics regulation. So to understand why the Bureau of Drug Abuse Control was so fragile and why the FDA ended up losing its powers, we have to look at the parallel history of narcotic regulation here. Now, the path of narcotic regulation was much different than the path taken for the regulation of amphetamines or stimulants. And this one was really rooted in exclusion, taxation, criminal enforcement. So let's talk about the first major piece of legislation that regulated narcotics. It was the Smoking Opium Exclusion Act of 1909. This law didn't regulate opium broadly. It specifically targeted opium smoking. So this was a practice that had been racialized and associated with Chinese immigrants. So this really functioned less as a health measure and more as immigration and social control. And this really set the early tone for how narcotics would be regulated in this country. This approach was hardened with the Harrison Narcotics Tax Act of 1914. Now, the Harrison Act was framed as a tax and registration statute, and it really relied on Congress's taxing power rather than an explicit health or police power. So it became very much a criminal taxation model. And the authority to enforce it was placed in the Bureau of Internal Revenue, which makes sense because it was a tax, it was passed under the power to tax and spend. Now, although it was passed as a tax act, federal officials used the Harrison Tax Act to prosecute physicians, particularly those who treated addiction as a medical condition through maintenance prescriptions. So this was early forms of heroin-assisted maintenance or morphine-assisted maintenance. And the Supreme Court upheld this approach, and this really pushed doctors out of addiction care during this era. And it cemented narcotics regulation as a criminal justice enterprise for criminal justice agency. The punitive trajectory continued with the Anti-Heroin Act of 1919, which prohibited the manufacture and importation of heroin altogether, even though it had previously been a legal pharmaceutical, right? Just like amphetamines and others. But so again, we're really here focusing on the punitive side of things. Now, within the Bureau of Internal Revenue, there was in 1921 the Narcotics Division, which was created. And again, it might seem odd to have a narcotics now in 2026 to have the Narcotics Division in the essentially predecessor to the IRS. But if you know a little bit about Prohibition history, you know that also the Prohibition Bureau was part of the Bureau of Internal Revenue. And so the Prohibition Bureau was given the authority to enforce alcohol prohibition laws. And it developed a reputation very quickly for moralizing rhetoric, fear-based enforcement, and construction of a quote-unquote criminal class. Now, we know that the prohibition collapsed, as did the Bureau of Prohibition, and it became criticized publicly as being a failure. But prior to the collapse of the Prohibition Bureau, in 1927, that narcotics division was put into the Bureau of Prohibition. All right. So we have the Narcotics Division put into the Bureau of Prohibition, the Prohibition Bureau fail, then we have the Federal Bureau of Narcotics that comes out of it. And so why is understanding the trajectory of where these agencies are important? Because the culture of the agencies are really drawn from these initial placements. So as well as their leaders. So Harry J. Anslinger, who's a very notable figure, right? He served as the commissioner of the Federal Bureau of Narcotics for 3 decades and only retired after he was forced into retirement. And he spent much of his career convincing Congress that narcotics and marijuana were existential threats and that we needed aggressive policing to contain them. But he came from the Bureau of Prohibition, and he saw what happened to the Bureau of Prohibition. So he made it his career mission to make sure that what happened to the Bureau of Prohibition did not happen to the Narcotics Bureau. Right? He was known for his colorful quotes. He would urge judges frequently to jail offenders, then throw away the keys. He saw people who use drugs as deviants, never as patients, and definitely had an enforcement first identity that lasted. And so we have the Federal Bureau of Narcotics, right? We have Narcotics Division goes into the Prohibition Bureau. Then the Federal Bureau of Narcotics emerges as the Prohibition Bureau. So we're in the 1930s now. This bureau was really grown out of the early policing under the Harrison Act, as well as Prohibition era policing. And so they never really looked at the drugs as a medical product to be regulated, right? They just policed. And they policed in ways that were, quite controversial. So they were so later testimony of FDA investigators when the two bureaus get combined later. I'll talk about that. But their quotes really, talk about how many of these Federal Bureau of Narcotics agents would brag about how they would take money from scenes of the crime and pocket it, how they would entrap people. They had a arrest quota that they had to meet and were very much driven by the arrest quotas. So we have the Federal Bureau of Narcotics now, and they are in charge of the regulation of narcotics. And so we're fast forwarding to the early 1960s. We have the FBN, and then we also have the creation of the Bureau of Drug Abuse Controls under the FDA. And they regulate stimulants, right? As well as anything that's non-narcotic and could be potentially addictive goes to the FDA, and the Federal Bureau of Narcotics has narcotics. Now, at this time, though, national attention is beginning to shift. So away from heroin and more towards recreational use of non-narcotic drugs like amphetamines, barbiturates, LSDs. These were often pharmaceuticals that were, again, legally manufactured but this was outside the jurisdiction of the Federal Bureau of Narcotics. Now, the Federal Bureau of Narcotics were very clear. They did not want jurisdiction over these drugs. Why was that? Well, it could be that there was really racialized distinctions that were shaping congressional thinking about drugs. Lawmakers routinely describe narcotics users as urban, Black, and criminal, while describing people who use prescription stimulants and sedatives as white, middle class, and its use as medical. And Anslinger himself espoused to this belief. Right. So in a congressional hearing, a representative put this distinction very blunt, asking Anslinger whether a person who takes sleeping pills nightly for 15 years was really comparable to a person who's addicted to heroin. And Anslinger's response was blunt. There's a tremendous difference, right? So they were very clear about their distinctions here. Now, regardless, because of the focus on stimulants being a national problem, and at this same precise time, we have Anslinger being forced into retirement. We get this 1963 President Advisory Commission on Narcotics and Drug Abuse. And what's interesting about that report is it really praised the FDA's work and said, despite how limited your resources are, you did a great job in addressing illicit pharmaceutical distribution. So we have the Bureau So we're starting to see the fall of the Federal Bureau of Narcotics as Anslinger leaves, and the rise of the Bureau of Drug Abuse Control, which is in the FDA. And they get an influx of money to hire new agents, and you see the FDA kind of doesn't know what to do at this point. So they're like, oh, we have all these investigators now, and they can hold guns, so we're going to send them to law enforcement training school. And so here's some pictures of the early law enforcement training school in Berkeley. But in addition to that, this is kind of the fatal error the FDA made. They went to the the Federal Bureau of Narcotics to ask for advice and guidance. Now, though they also then actively recruited law enforcement officers from the Federal Bureau of Narcotics to help staff their new bureau. What the FDA officials at the time didn't know was that many of the FBN agents that were seeking to transfer were under investigation for corruption. And the Federal Bureau of Narcotics was so eager to get rid of them that they did not tell the FDA that these people were under corruption. Not only were they hired to be agents of the Bureau of Drug Abuse Control, they were often given leadership positions and promotions. And so despite this, the FDA still made a very deliberate leadership choice and put John Finlater as the director of the Bureau of Drug Enforcement. Now, he was not a career law enforcement agency. He was actually an experienced administrator. He described his vision as statistical, psychological, and an educational approach. And he often rejected the idea that people who use drugs should be defined as deviants, right? So he said, I'm more interested in really looking into the basic problems that lead to drug use, as opposed to just making cases and putting people who peddle drugs into jail. So very different. But despite that, here's some quotes from the FDA investigators at the time. Initially, we had a pretty good operation. Then when they went into narco, it became a different situation. These Bureau of Narcotics guys who knew nothing about the FDA or nothing about our cases were put in charge. and so we start to see the BDA, Bureau of Drug Abuse Control, become very overwhelmed by the different standards, the different credibility, the different ethics, and folks begin to leave or begin to be transferred. But also the experiment ended pretty quickly. In 1968, just 2 years after its creation, the BDAC was removed from the FDA. So President Johnson, acting on the recommendation of the FDA Commissioner Goodard, merged the BDAC with the Federal Bureau of Narcotics and transferred the combined agency to the Department of Justice. And one of the reasons that Goodard wanted it transferred was because the agency was starting to get out of control and really become more of the Federal Bureau of Narcotics anyway, because it had been taken over by these agents. So the resulting agencies is Bureau of Narcotics and Dangerous Drugs. And Congress was divided about whether or not this was a good idea. Some lawmakers warned that the Department of Justice lacked the capacity to regulate illicit pharmaceutical markets, and questioned whether this was just an overreaction at the time. And then kind of what the seal of death was on the public health or health-oriented approach was John Ingersoll, who was a former street cop, was appointed to head the Bureau of Narcotics and Dangerous Drugs. So the outcome was clear here. The criminal justice model won out, and that set the stage for the Controlled Substances Act and the rise of the DEA, which subsumed the Bureau of Narcotics and Dangerous Drugs. Controlled Substances Act passed in 1970, aimed at addressing, quote, the illegal importation, manufacture, distribution, and possession and improper use of controlled substances, created a drug scheduling system, right, which I'm sure Professor Lawrence will go over in more detail. But the structure, and also created the DEA, which was President Nixon's police agency, essentially. He had campaigned to strengthen federal drug enforcement, and the DEA was going to be the vehicle that he did that. So the result is the system we live in today, a drug regulatory framework where medical decisions are filtered through law enforcement priorities. Public health expertise are consulted because the Controlled Substances Act requires that the DEA consult with the FDA. But the DEA, not the FDA, has the primary authority, right? So that again brings us to our central question. Why the DEA and not the FDA? Why is the DEA responsible for regulating potentially addictive substance? The common explanation is that the FDA was overwhelmed or incapable of handling drug enforcement. But if you really look at the historical record, it tells a much different story. When the FDA, through the Bureau of Drug Abuse Control, or even before, was given authority over stimulants, it didn't fail at its duties. The FDA investigators made cases, they documented diversion, and in some instances, it actually outperformed the Federal Bureau of Narcotics. But the loss of authority really had less to do with capacity and more to do with institutional risk, right? Public controversy, internal sabotage by the Federal Bureau of Narcotics, and leadership discomfort with kind of this undercover policing. So what ultimately prevailed wasn't a better model, but it was a more entrenched one, right? The criminal justice approach completely displaced any possibility of a regulatory, health-oriented approach. And that was later cemented by the Controlled Substances Act and the creation of the DEA. So importantly, today, the FDA is not the FDA of the 1960s. It even has an Office of Criminal Investigation staffed by sworn agents who already investigate fraud, diversion, and illegal drug distribution. In other words, the FDA has both scientific expertise and the enforcement capacity to regulate these substances. So if Congress is really serious about treating drug misuse as a public health issue, it really must consider which agency is best suited to lead it. And the question is not whether the FDA could do this. It's whether we're willing to actually move beyond this century-old policing and enforcement model and choose a health-oriented approach over punishment. And that's it. That's all I got for you today.
That was awesome to lead as always, and I'm gonna get my clicker. So let me say first, thank you to Regina and Shelley for having me. And second, I learn so much every time I hear Talid talk and read her work, so it's just a real treat. And I'll flag that Talid had a few slides with credit to the DEA Museum. And that's just a quick ride on the metro over to I think it's like the Pentagon City stop. And you can walk over there. It's free to get in. It's very interesting. I love going to museums because you can see not only what they've got, but the choices they've made. And that would be a very, like, if you're trying to learn about the culture of DEA, I think it would be like an interesting trip. And then also they're right in the lobby of the headquarters. You can see the Faces of Fentanyl exhibit that Ann Milgram put in, where just on the wall, they have more than 7,000 faces of people who passed away. And anyway, so for consideration, I'm going to talk about CSA scheduling, statutory and regulatory reforms. I think I have five, start a timer. I have, I think, five learning goals for you, and maybe the things you already know. So then it's like discussion goals. First, just to talk about marijuana scheduling and where it is right now. Second, to talk about Controlled Substances Act scheduling generally, using the kind of marijuana example. Third, talk about how we ought to fix scheduling generally. And then that's going to be in the statutory realm. And then I want to talk about, in the regulatory realm, focus fourth on methadone regulation and barriers to accessing methadone that come from the regs. And then fifth, regulatory fixes, how we could make change. And I'll focus especially on changes that would not require legislation there or even DEA compliance, but that a state or health system could potentially be driving through the courts. So I will dive in. Can I double check what did we do wrong? Do I have to turn it on? It's on.
They're not working.
I got it.
It's all right.
So quick conflict disclosure, part of the project grew out of a National Academy's report, and I served with DEA from 2022 to 23. But everything here is my own opinion, not that of any, lawyers. And Regina and Shelley were instrumental in that National Academy's workshop on methadone access that I recall. So I want to start with marijuana and what's going on with marijuana. And so I actually want to start last, January. So President Biden had ordered the rescheduling of marijuana from 1, which is a blanket prohibition, to 3, which allows for some medical access. But as we're going to get into, everything Talid just talked about, it is not President Biden or Trump who controls drug scheduling. It is DEA and the Department of Justice. And so actually the way drug scheduling works is they have to go through a formal rulemaking. Raise your hand if you know rulemaking, formal rulemaking, APA, we're 60%. Yeah, but formal rulemaking, you have to put out a notice, we're gonna do the thing. Then you have to get comments, then you have to have a hearing, and then you get to a final rule. And so that's a long process where they're supposed to make this decision. And what happened last January is Biden orders them to think about it. Then the Attorney General initiates the rulemaking. I want to come back to that. It was not DEA that initiated the marijuana rulemaking. It was the Attorney General. And then they have to figure out the witnesses for the hearing. And there wound up being this big, here's a block of footnote from the thing. That's footnote 5 from one of these interlocutory orders. There's just this big controversy about who's going to get to have witnesses at the hearing. And there's allegations, I was not involved in any of this at all at DEA, but there's allegations that DEA had tried to encourage certain sorts of witnesses to cook the books against marijuana rescheduling, which is sort of what's in this footnote. And what winds up happening is that the ALJ, who's hearing the hearing, just winds up canceling the hearing. That was last January. And so it's just off the books. And then it just sat there. That wasn't last January. I'm sorry. It was
January 2025.
Yeah. So then we're just sitting, watching what's gonna happen. And then Trump comes in and everyone's just sitting, what's gonna happen. And then the news, but nothing, in the process, DEA had proposed rescheduling. It was just out there. And the hearing was just in abeyance. It was just what's gonna happen? And then along comes the order from President Trump, which is increasing medical marijuana, and then this was in the headlines. Raise your hand if you saw the headlines. It's President Trump announces we're going to reschedule marijuana, and the same dance. I teach leg reg, and I teach that, and it's just always the dance. President does something in an EO, the headlines will just pick up the thing happened, and this is across presidents, and then the lawyers figure out what's actually happening, and every reporter I talk to, this is an aside. I'm just you can't report this way. That's not what's happening anyway. So here's actually the text of the order from President Trump, and it says, the Attorney General shall take all necessary steps to complete the rulemaking process related to rescheduling in the most expeditious manner possible in accordance with federal law, including 21 USC 811. Now I want to flag 2 or 3 things about this. I wrote down 3. First, just obviously, it's just complete the rulemaking. This doesn't say reschedule. The order says complete the rulemaking, right? That's point 1. Point 2 is the order is directed to the Attorney General, not at the Drug Enforcement Administration. And that's similar to the reschedule. It's actually like in the public documents about the Biden rescheduling effort, that there was a dispute between DEA and HHS about the rules for rescheduling. And it winds up being that the Attorney General signs the order, not the DEA, to initiate the rescheduling process. And if you go look at rescheduling orders, the DEA administrator signs them. But that one was the Attorney General, because the Controlled Substances Act gives the power to the Attorney General. Everywhere in the CSA, the power is Attorney General, Attorney General, Attorney General. And then there's just a subdelegation to the DEA administrator buried in the law books, right? Normally we ignore that. We just have DEA do it. But what we saw in the Biden administration is that the difference started to matter. And here you see this direction is to the Attorney General. So that's Pam Bondi. This is to you, not just to the DEA administrator, at least as written in this order. And then the third thing I want to flag, this is unusual in an EO. Every EO, I worked at OMB on the EO, like some of this, EOs always say, if the president tells an agency to do a thing and that thing is illegal, then you're gonna be in trouble. You can't do it. EOs don't have the force of law. The agency has to have legal authority. So they always say, do it in accordance with law. This one doesn't just say do it in accordance with law. It says, including 21 USC 811, which I'm not used to seeing, not just in accordance with law, but including that provision of law. And that provision of law is the CSA provision about drug scheduling. So the legal framework we have is the Controlled Substances Act. The statute, which the agency cannot change, sets out 5 schedules of drugs, 1, 2, 3, 4, 5. The statute then says, here are the criteria to think about in switching between the different schedules, which we're going to talk more about in a second, and some of them are on here. Currently accepted medical use, pattern of abuse, things like that. That's in the statute. That's all in the statute. And so what this EO is saying, it's not only think about rescheduling marijuana, but don't necessarily do it, but it's referencing the statutory factors, which means that the agency, it's saying you have to go think about the factors, which means you have to do the same consideration of these factors that is often a kind of a challenge for CSA scheduling. So a little deeper background on that. This chart, which I'm going to dwell on for a second, is an effort to just describe the CSA scheduling framework in a chart. So let me go left to right on the columns. I know that's the worst thing in the world to do. So first what I want to say is the CSA, it's 5 schedules, which are set up by the statute, but really I have a co-author, Dave Posen, and we have an article coming out in the Harvard Law Review that goes through a lot of this. But really there's 3 models of access to controlled substances in the CSA, and they're kind of across the 5 schedule. Model 1 is prohibition, right? And that's basically Schedule 1. If a drug is placed in Schedule 1, then it is not permitted to be used. There is not a way to access it except with some very limited research applications and the like. The second model is medical access. If a drug is in Schedule 2, 3, 4, or 5, if you want to use that drug, you have to go to a medical professional and they have to give you some kind of permission, usually a prescription. There's some isolated examples where you don't need a prescription, but it's through the medical system. And then the third access model is laissez-faire. If Kratom, DEA, DOJ just does not schedule a thing, there's just not a federal regulation of it at all. And if there's regulation, it's FDA for medical marketing, which is its own thing, or there could be potentially state regulation, but there's no federal regulation. Does that make sense? So legal status of those is prohibition is Schedule 1, medical access is 2, 3, 4, and 5. And then laissez-faire is just you don't schedule a drug. Now I want to jump all the way to the right. This is from that 811. Here is what DEA is allowed to consider, or DOJ, when they're deciding about how to schedule. Potential for abuse, risk of physical or psychological dependence, and currently accepted medical use and treatment. So they're going to consider those things and put it either in Schedule 1 or in these kind of gradations of 2, 3, 4, and 5, or they're not going to schedule it. They're not going to control it at all. Does that make sense? Now, I want to highlight some things that are like missing from this. So first of all, so that's the law as it is. And let me just pause for a sec. That's the law it is. That's the framework our United States is dealing with in making drug scheduling choices. This is what we can think about. These are our menu of options. And that's what we can do as an agency, or we can have Congress step in and do ad hoc legislation and things like that. So first, if you just look at the considerations, is there anything missing from this list of considerations that any thoughts on something missing from this list of considerations? We were talking this morning about collateral consequences of getting arrested for a drug crime. So where would those fit?
Oh, yeah.
Right? So it is irrelevant under the statute, the harm that will come from foreseeable misuse, arrest, punishment, any of that. That's just irrelevant here. What about access for people who use the drug but don't get clearance, medical clearance, right? Like marijuana rescheduling, right? Where's that in here? What about preventing overdoses from illicit use, right? Like if we put this thing in Schedule 1, if we have heroin in Schedule 1 and there's no way to access heroin, then the people are going to wind up, and we cut off supply, they're going to go to fentanyl, right? Where's that in this list? So it's just missing. And the point is, like, have you done like cost benefit analysis, discussion of that? Anyone familiar with that? It's like routine admin law that if like EPA is considering how to regulate pollution, they're supposed to consider the costs of their regulation and the benefits of their regulation. And then like the costs have to, be outweighed by they have to justify it. And if an agency did only this, then a court would say it was arbitrary and capricious. That's invalid because you do not consider all the likely costs and benefits, but they're just missing from our statutory framework. They're just missing. Another thing that's missing from our statutory framework is, and I think maybe, so I have on here examples, like prohibition right now is cocaine, marijuana, MDA, medical access is like Xanax, OxyContin, and then like lazy affairs like kratom, alcohol, nicotine, and that kind of thing. Anyone follow the kratom discussion? So kratom's it's a very, DEA decided not to schedule it. When I travel in public health circles, there are a lot of studies about are we concerned about harms of kratom? But on the other hand, if you schedule it, then you have huge access barriers right off the bat. And so you've got this classic access, access versus harm trade-off. So something that's not missing here, or that's missing here is like a safe injection site, right? Where somebody might go and use drugs, right? Right now you've got the Department of Justice saying safe injection sites, like with the safe house litigation, that's unlawful, right? Not only are they saying it's unlawful, there's not a schedule where we could say that drug, safe injection sites, ought to be lawful under certain criteria. Does that make sense?
Yeah.
And then,
Just a question, doesn't that judgment rely on the determination that the purpose of the site is to use illegal drugs?
great point. So we could get into that. And there's,
Then you guys say, well, we're trying to save lives, et cetera, et cetera. You get into that debate.
yeah,
right?
and so what we could get off into, yes,
Yeah.
agreed, but we have nothing on harm reduction. And then also just, New York Times had an op-ed yesterday, I think, about marijuana legalization, saying well, maybe legalization is a good idea, but we want to regulate it, right? Like you hear people say, alcohol, tobacco, they're legal. Why shouldn't marijuana be legal? Alcohol is subject to advertising restrictions. You get there's limits on access. There's limits on the hours that people can buy alcohol. There's limits on the form. Tobacco, there's also lobbying restrictions for tobacco. There's also other kinds of uses. We do not have a schedule for regulated market access either. Those are just missing, which means it's just not an option when the federal regulators look. I saw a hand.
Weren't they specifically omitted from the legislation?
Alcohol and tobacco were specifically omitted.
Yeah, so,
Agreed. And so then when we get a drug like kratom, so I'm not saying we want to schedule alcohol and tobacco right now.
right,
Although actually, if you wanted to harmonize your thinking about
Yeah.
our drug regulatory system, in a way, we have a schedule for alcohol and tobacco that it's not in the CSA framework. It's just these are established drugs where it's not medical, but we need to regulate it. And so what I'm getting at, and I'll jump to that slide, is now I'm a law professor, so having explained the way things are, I get to talk about how things should be for like a second. And so if you just put in what we've done in italics here is to say what Congress ought to do is amend the CSA, not to legalize marijuana or to change alcohol regulation, but to add like a managed market access schedule where the regulators could say with Kraton, well, we don't want to make it medical access only because that's way too limiting. But laissez-faire's got a bunch of problems. So we're going to put it in the managed market access schedule where there are advertising restrictions, there might be lobbying restrictions, there might be restrictions on IDs, things like that at a federal level. And then also add a schedule for harm reduction where regulators could say, we're very concerned about like heroin, we want to keep that prohibited. However, we actually also need to create some opportunities for harm reduction centers to allow access and to oversee access, and for that not to itself be a crime. And just make clear we're not going to run into the like crack. So you could maybe do that through an interpretation of the crack house statute, which would be a separate thing. So that's kind of, point one is that that's an amendment that I and my co-author would like to see to add schedules. Another way of thinking of this is right now, if you're like, what model of access should we have for this drug? It's a multiple choice question, and the CSA does not give the right answer for many drugs. And it's just a gap in the CSA, so that Congress ought to fix that. A nice thing, like just as a side note on political feasibility, often Congress likes to do things that it can say it did something, but then it's left to the details later, and then they can even complain about how an agency filled in the details. And so we're actually suggesting here, add these schedules, but you don't actually yet have to commit to any drug being placed in any schedule. That could be figured out later by the agency, and then you as a Congress member could have your cake and eat it too. And if you all know any Congress members. And then also, I think it's very important to add to the CSA's factors for consideration in deciding about scheduling, things like the social and fiscal costs of prohibitions, right? All those harms we talked about this morning are relevant if you're deciding to prohibit the thing. You can't just, and also religious, recreational, and other benefits from non-medical use. Yeah.
Have there been efforts to change the CSA in the past? Is this feasible?
So I actually have not found a proposal out there that says like, yeah, we should, rather than legalize marijuana or legalize particular drugs. What's been happening is the CSA creates a categorical framework that is drug agnostic. And then people who don't like it for particular drugs advocate ad hoc drug-specific departures from the CSA. But nobody goes back and fixes this thing that we've had for 50 years and has these underlying flaws. Yeah, Regina?
Are there any, yesterday we talked about the international schedule, international treaties. Are there any restrictions under the international treaties for what's being proposed?
Great question. So first, yeah, the international treaty framework can be interpreted to require us to do something along these lines. Two hesitations about that. First, there's a couple of international law scholars who've written, and it's relevant for marijuana, that there's provisions of the international treaty that would allow for managed market access if a country determined that prohibition of that substance would itself cause medical or public health harms, right? And so there's some steps there, but it's not like we can just do managed market for anything we want. There's a provision of the treaty that would allow, we can do managed market if we actually think that that's the better public health approach for that drug, given the harms of prohibition. And that argument is out there. And then the second point is that right now, they're doing a review of the international drug regulatory framework. And all the arguments here are reasons that the international regulatory framework also should be changed. And so as long as they're reviewing that, we would suggest the same thing. Of course, now we're talking about different level. And then, did I see another hand? Yeah.
Oh, that's like what Bolivia did with the coca leaf, something like that?
Exactly.
We want to do that with marijuana in the US.
Yeah, and the coca leaf stuff on the international level is part of what's driving some of the reform discussion at the international level, because we have a very similar challenge. There we've got religious and traditional justifications for use that are not necessarily medical, but nonetheless might be compelling given the risks. And so that would be another reason you need like an extra, layer, or this would answer it. So anyway, that is a pitch for that kind of reform. I want to say a third thing about that, which is Talib talked about whether DEA, which is kind of, in our world, there's disciplines with expertise, and there's public health, and there's medicine, and then we can talk about whether public safety is an expertise, but they definitely think it is a DEA. And so there can be a question of like, which of these these hard drug policy questions, what's the right expertise to solve them? Medicine, public health, public safety, and in a way the coca leaf thing gets at this. Just a final point on that my co-author and I agree on is that none of these disciplines can answer all of these questions for us. They can tell us the values, what the risks are, maybe give us a sense of the benefits. But a lot of these decisions are ultimately political decisions that are about big trade-offs. First, about how to try to address drug regulatory problems. Should we be using like regulation at all? Or should we be just investing in, upstream controls or something? And how do you weigh burdening religious practice, burdening hundreds of millions of people's recreational use versus public safety impacts? Like, how do you weigh that? Ultimately, that winds up being a political choice. And so whether it's FDA, DEA, or whoever, we actually like the idea that it would go up to closer to the president level and have more political ownership of these judgments. We think that that's fine, that was right for Biden to do, and that if Bondi is now involved in scheduling, we would defend that. Yeah.
I have a question about the managed market access category. Did you all consider state control versus capitalism control?
Yeah.
Just because we know that, capitalism has controlled tobacco and alcohol, and there's been a lot of harm that's been caused because of that. And even with marijuana, we've had really high THC levels because of capitalism.
Yeah, and so that, my co-author's not here. I think if you, there's a big question of what your capitalism controls would be. And then same too for your harm reduction schedules. And I think in the harm reduction schedule, at least you would probably have a prohibition on for-profit sales. You'd have some kind of regulation on who could, to try to address some of those incentives. But let me come back to that because I have 10, and I want to get through this whole other thing on, that's statutory reform. I now want to talk for 9 minutes about methadone regulatory access. So raise your hand if you have some familiarity with the methadone regulatory framework. So I can go pretty quick, especially beginning. In our world, the norm, the default I want to start with on the top of the screen is the rules for medical practice are determined by states and by medical professional leaders within the states. So what I mean by that is when a prescription is legitimate for a painkiller, that's determined by medicine, not by the federal government. And in fact, there's a norm of federal non-interference. So if the federal government comes in and says, here's when you should prescribe opioid painkillers, and CDC issues guidance on that, there's always a lot of resistance out there. They're like, wait a second, you're getting into the judgments of the discipline and everything. We do have one big exception to that, and we could talk about some other sorts of exceptions. The one big exception is methadone. The Controlled Substances Act was amended. So first, the Controlled Substances Act incorporates medical control of prescribing. So the DEA, they tried in the Supreme Court and they got rebuffed. DEA does not get to tell prescribers when a prescription is legitimate. That's referenced by state and local licensing standards. Does that make sense? Except when it comes to methadone access for treatment of opioid use disorder. The Narcotic Addict Treatment Act, that's the name, federalized methadone treatment for SUD only. So all of these other illnesses out there in the world, prescription behavior, the judgments are decided by medical practice. But methadone, they are decided by DEA plus SAMHSA through the regulatory process on a national level. And that was a decision made by the Narcotic Addict Treatment Act. And I think a lot of you probably already know some of the huge challenges that there are currently with the practice standards that for this one sort of treatment are determined at the federal level by two agencies rather than by doctors and professionals in the local setting. And so it's just a barrier. And what it's done is it's ossified the status quo for 50 years. It's incredibly hard to make changes. We know this chart, well, whatever. Well, I'll do it quick. So if you want to make changes in access to methadone, right, you need permission and you need payment, right? We can't forget about the payment piece. And for permission, like if I'm in Georgia, you need DEA to be okay with it. You need SAMHSA to be okay with it. You need the accreditors to be okay with it. You need the OIG to be okay with it, especially if you're doing something like contingency management or something like that. Then you're also going to need, like in Georgia, you're going to need the state funders. You're going to need Medicaid, which means CMS, maybe Medicare, maybe the Medicare Advantage plan. Then the provider, hospital, health system, prison or jail has also got to get on board. This is like a nuclear bomb, you need 2 keys. It's like if we're gonna allow a person to get methadone for their opioid use disorder, we've got like 10 keys, right? And we're gonna get, they all got turned at the exact same time. And that is it is direct result of our structure for how we make decisions about the treatment standard and nothing else. And then it ossifies things. And so we wind up stuck. And, the take-home flexibilities in COVID are a great example of this. A lot of people are like, take-home flexibilities, we should have them prior to COVID. And the answer is always, we have a system now, you're proposing a change. And it's a national change because our system is national, right? You're proposing a national change. How do we know what's going to happen? And what happens might hurt people, right? Therefore, we're not going to do it.
Despite the fact that not doing it hurts people.
Then COVID happens and we are forced, COVID happens and we are forced to make the national change. And lo and behold, with take-home flexibilities, it's fine. It helps people and doesn't hurt them. So with that one, we then say, okay, now we're going to make that permanent and national, right? And now there's all these other proposals. Prescriber methadone, more access in prisons and jails, nursing homes, things like that. And we do the same dance. How do you know what's going to happen? How can you make a national change to the way people get addiction treatment and you don't know what's going to happen? Well, that's because we're only doing this as a national change because we federalized addiction treatment. So then just to get to like other healthcare programs, I think that's the next slide. I promise I'll stop in a sec. Oh yeah, there's an example of a law that's like runs in modernizing opioid treatment and access act, which runs into these concerns. How do you know what's going to happen? There's uncertainty. It's going to hurt people. You can't make that change. And so here's other healthcare programs. Like I study health law and how they make changes. Medicaid, they don't make big national changes all at once. They try them in a state, see how it goes, and then make the change. Medicare, federal default, does demonstration pilots all the time. ACA, No Child Left Behind. This is how drug you get the point. Federalism. This is like not a new concept in the American system of government. If we have a big change and we're not sure what's going to happen, we allow states to make the change. We see how it goes, and then we decide whether to do it nationally. And yet, the big exception is methadone treatment for substance use disorder. We can only make the change federally all at once if these 2 agencies turn the keys. It actually just makes no sense, right? And so what we ought to do is allow waivers for states, or I would say healthcare systems, that have an idea. I want opioid prescribing. I want better access in prisons and jails. Maybe a prison and jail doesn't have to register as an OTP, something like that. I want to make that change. I want to try it in Maine. And then if it works in Maine, we can do it nationwide. And anyway, that's just something we should be doing routinely in order to modernize access to methadone. And then I won't go into this whole slide, but there is legal authority in the CSA to do so. And I have an article on this called Defederalizing Opioid Addiction Care, something in the San Diego Law Review. And you can read all the footnotes and the statutory analysis and the whole deal. I'll just tell you that there is a provision of the CSA that gives the Attorney General power to waive the requirement of registration by regulation if found consistent with public health and safety. If you follow the mobile methadone ban rule, that worked through this waiver. And the same legal authority that got you the mobile methadone ban rule could get you opioid prescribing in Maine or you name it. It's really not hard. And the legislative history is also supportive of it. And if you're super wonky, well, raise your hand if you know the major questions doctrine. We'll skip that. You can read it in the paper. That's an admin law conference. And then also they have a separate authority for research authorization. So there's this separate authority for something that's part of a research project, doesn't even require regulation, that they could then grant a waiver. And that goes beyond methadone. If you come to me with your idea for changing the CSA framework, and there's a good chance that it fits through one of these 2, or even easier, a lot of them, and I'll conclude here, would fit through this 3rd one. There's a regulatory provision. If there is a requirement for drug regulation that comes from the CSA regs rather than the statute, so it means it's not actually required by the CSA, but DA is put it in the regs, then they can waive it with a letter, and anyone can apply. And if you read the regs, you think oh, that's a person applies. And that's, if you go look at some of the precedents that are public, it's this doctor applied, that kind of thing. But if you go look at COVID, they waived it for whole states. They wound up doing it for the whole country. You could go look at all of those for precedents. And so there's a lot of things 3-day rule for emergency methadone. Are you familiar with that? Yeah. You could push that to 20 days for somebody discharged from a prison or jail, right? And you could just do that with a letter. A health system or something like that. Now you have to get DA to grant it. So actually I'm going to click. physician prescribing, suspicious order reporting, telehealth, and I will conclude here. I'm not gonna do that. So it could be that this is led at the federal level, right? That the agency pushes for this. But a lot of these changes and a lot of changes over the course of the history of the DEA, you see litigation being really, really powerful. There's something called a petition for rulemaking under 553 of the APA, where anyone can send a letter to DEA, say, you ought to make a rule, you ought to change the rule this way. They can take a year or two to decide. That's how it always goes. Then they deny it. Then you go to court and you challenge their reasons for denial. And then you've got a lawsuit. And then there's cases, I mean, I think it's where that's happened. And a lot of our like rescheduling fights are because petitions for rulemaking wound up getting into court. Even if it's not successful in court, but it sometimes is, it drives a lot of popular attention, which in turn can drive things. And so again, if like Maine were interested in any of this, I keep throwing out Maine, there's like Maine could submit the letter tomorrow and start the clock. I used to defend the government and we always said, hell hath no fury like a patient plaintiff. Start the clock, you just start pushing on any of these in order to get change, especially if you think we're in an environment right now where federally led change isn't gonna happen right away, although I don't really know. So I will stop there, but I have some additional reading on there and look forward to the Q&A.
Could we close the slide so we can see Talid in case folks have questions for Talid or Matt? Thanks.
Talid.
Great.
Hello. Were you able to see me when I was speaking, or was I a disembodied voice?
I want
Disembodied.
to say that I hope that the Wayne State and Emory law students appreciate your clarity and how you presented. I would have probably done much better in law school had I had you two.
Aw, thank you.
Go ahead, any questions?
Thanks to you both. So can you talk, a really fascinating presentation, and especially the last idea. Can you talk a little bit about the impact of the overturning of Chevron deference potentially on, you know,
That's a great
that
question.
lens on all of this potential to use kind of the administrative law process to push reforms?
Yeah, that's a great question. So you have on the books a lot of old regs, and then some of these statutory authorities too, where if you went, you know, you might well, if you, let's say you filed a letter and you said, I want you to make this change, you might well get a response back from the agency that says, we actually read the statute different than Professor Lawrence, and you can't do that, or something like that. And previously, the rule under Chevron was that if there's any doubt in the statute, the agency's interpretation is correct. And that was the Chevron rule. But now the Supreme Court has reversed that under Loper. It's if there's any doubt under the statute, the court resolves the doubt by reference to statutory arguments. So any doubt about the interpretation of some of these flexibilities would have been resolved against flexibility if that's what the agency wanted in the Chevron era. But now that Chevron has been reversed, that doubt would no longer be resolved that way, and we would just be in the statute books doing chapter and verse, like I lay out in the law review article I mentioned. And then I would just also throw out another case, which is Corner Post. So another big Supreme Court case in administrative law recently, Corner Post said it kind of basically extended the statute of limitations on challenges to regulations and whether they're arbitrary and capricious or have other kinds of problems with them. So take like the 3-day rule or something like that. That's decades old. So that would have been outside the statutory limitations, you know, to sue about, except Corner Post says, no, it's not. There's certain caveats. There has to be like a new entity that's suing about it. But like, I've been kind of waiting to see the post-Corner Post, post-Chevron pushback by the like regulated community against the kind of status quo that was built up prior to those opinions. And I have not yet, you know, seen it, but I'm not a litigator. But yeah, so I think it's a great point about the potential relevance. And it also goes, as one last thought, is there's an interagency point too, because Chevron to Loper means that like HHS and DEA had a big fight about the meaning of currently accepted medical use. And Chevron would say like, oh, you should kind of defer to the agency that administers the program. But Chevron's gone. So if HHS, SAMHSA, DOJ, and DEA are disagreeing today, no longer to say the DEA attorneys get to say like, this is our statute. Supreme Court says, no, this statute belongs to whoever's reading the text and comes up with the best reading. Yeah, I'm gonna go like this.
Just a quick note, maybe. So I was at SAMHSA and kind of was the director for the Center for Substance Abuse Treatment when we changed the OTP rule. And so the in carceral settings don't actually need to register as an OTP because there is this designation, even within the DEA regulations, that you could be a hospital/clinic. And there are some states and a whole bunch of kind of county jails that are really trying to implement that. It has not been without its challenges, I will say. And and I'd be curious about your, Professor Lawrence, your perspective on this, because my understanding also is the DEA as an agency is very decentralized. And so there's a lot of kind of decision-making that rests with the field agents.
Yeah.
And that's where a lot of the implementation, even of many of the changes that we made and, you know, many of like the waivers, et cetera, that's where things very much get stuck.
So first, yeah, I should have meant, that's a great, that change was really important and terrific. And second, I think a question like that change, which is, yeah, a prison can register as a hospital clinic. And so then it can take advantage of flexibilities there. If there's challenges in implementation, that's something that whoever's trying to do that could cite in saying that they need even greater flexibility. And then as a third point, I totally agree with you about, DEA is it's largely decentralized. The field offices are doing a lot of the enforcement work. And that I think is an additional reason that state-based waivers make a lot of sense, because the state of Maine, I keep going back, could say to DEA, you know what, actually, we want to handle our own methadone regulation. We want you to just get out of this business in Maine. And then the field office in Maine would, of course, well, I don't know if they, I don't want to get ahead of anyone, but regardless, it would then become clear to everyone that actually the DEA field office in Maine didn't have any role in that because the state was operating under a waiver where it was going to run things itself.
Yeah, I mean, on that, I think the DEA in several histories that have been written about it, right, is their field offices, they're kind of seen as lone cowboy offices. It's very difficult to get all the cowboy agencies to comply, right, with even if you have a director that's on board with things. And so I'd be curious, I think it's a great idea, Matt. I don't know that I have faith that I think there's gonna be some turf war issues. I think that the field offices are gonna do what they want to do. And I think they may, so they may not look to focus it on are there other ways that they can say that they have jurisdiction using other parts of the statute, and still continue to harass some of these OTPs or doctors?
I mean, I think, Talib, you raise a good point, which is that as long as the local field office has kind of registration threats as to local providers, it would be very helpful if they were completely on board or something like that. Now, we didn't get into the possibility that maybe raises the possibility that what a state does is opt out of DEA Controlled Substances Act. Often the states have their own piggyback regimes. And so that maybe if you're really worried about that, you think even bigger and you say, you know what, we're just going to have the DEA registration process step aside for 3 years in this state while we implement this. And then maybe we can bring them back in while we've tested it, but we're going to limit it to the state authority. Even if it's a 1 year or 2 year time that they have to step aside, like DEA provider registrations or what, aren't they like a 2-3 year span? 3. And so, you could even say, hey, look, if we're doing 3 years, that's actually no different than when they, something like that, and just have that experimental window or something like that. But I think you're both talking about the sort of thing that would need to be thought through to effectuate any of this. The one last thought on all of this, I'm so sorry, is health systems. So health systems are increasingly powerful and consolidated. So if Geisinger in Pennsylvania does this, then they have a lot more ability to push back against or even work collaboratively with the local field office than your like local mom and pop physician. So if Geisinger gets a waiver, or even in partnership with the state of Pennsylvania, they do it, then you can also navigate some of these challenges, I think, more effectively than trying to do it with, again, the sole practitioner who's not going to have that ability to collaborate with the field office or even push back if necessary.
But that was the point I wanted to make is we've got these with managed care and with, you know, the government's intrusion into care. We've given these healthcare systems the ability to regulate through payment. So even if we get all of these other people to say, it's okay, we don't mind, the systems can say, you can do it, but we're not gonna pay you for it. And then it's in effect.
You're absolutely right. So the slide I skipped is really, I would, if I were sitting in, I keep going, I'll stop with Maine. I'm from Rhode Island. If I were sitting in the State House of Rhode Island, I would say this has to be a consolidated waiver. We have to apply to HHS and to DOJ simultaneously. And we want to get a Medicaid waiver. We also want a Medicare Advantage demonstration project. We also want to fold it in Attorney General, you know, this waiver for CSA. We want to get it all folded in and collaborating, you know what I'm saying? So we're dealing with the payment piece and the permission piece simultaneously. And then one other advantage of that is the more agencies you bring in, the more it is a political choice that's going to be made at the kind of like levels responsible for political choices, rather than at the like at the you know, the lower levels where there might be more friction to change.
And let the lawyers sue United Health to get them to pay for it.
Maybe so. Yeah, okay.
Thank you for featuring Maine. Let's talk about OTPs. Because you haven't talked a lot about that. What I see as a temporary regulator is that they're very good at arguing that they want great liberality in terms of how they operate the take homes and all that. And then you talk about allowing physicians to prescribe from their office, to virtually put these clinics out of business. And you then face a significant political opposition. They have their own trade association, as you know, and I realize I have to be careful of the media here and listening. I love my OTP. But that would seem to be, I love what you're saying, because I, as a layperson, I absolutely believe that we should treat it like buprenorphine and it should be accessible. And I mean, and we've had it around for 30, 40, 50 years, however long I've been there. But the political situation in this country and in the states and the OTP, I mean, I just don't see this happen. I just think it's the right thing to do. And politically, it's very hard to get there.
Tilly, do you want to start? Any thoughts on this?
So I didn't hear the beginning part of the question. Sorry.
No, it's essentially the problem, Leba, of having the opioid treatment programs, the methadone clinics, so to speak, you know, being very powerful politically and not wanting to basically allow access through even addiction trained physicians. With that model would put them out of business.
In addition to that, you have the power of the drug testing companies, right? The political lobbying power of the drug testing companies at play, I think, that go hand in, and you know, the current payment model, right? That I think all of these push back against meaningful reforms in methadone, in the space of methadone. And you know, methadone has been around for what, I think it's about 80 years now, actually, 70 or 80 years. So it's been around for quite some time. But yeah, I mean, you're hitting it spot on, right? I think you have lobbying groups that are very invested in keeping things status quo. I mean, you know, I've been very critical before of OTPs in the sense that the payment incentives just don't align with the best evidence-based care, if you think about it, right? So even if we have evidence that drug testing folks all the time is not, you know, in their best interest or not in their care, does not improve outcomes, et cetera, but you can bill for that, right? There's all types of kind of perverse payment incentives that exist, and you're right, that's going to stymie reform. care is concentrated in OTPs right now. So what happens if you allow physicians to prescribe outside of OTP then, or what happens if you allow pharmacies, right? In other countries, we have pharmacies that can dispense methadone. And so I think you're right. And how do we, I don't know the answer to how we kind of push back against that political capture currently. Aside from the actually, I take that back. If the AMA were to take more of a stand, and the other politically powerful groups would push against the OTPs, then I think you possibly could have some solution there.
And I would just add, like, I mean, I think first that I don't, I deal a lot with situations where there's a group with an economic interest in certain outcomes who advocate for those outcomes. Sometimes they've got a fiduciary duty to do so. If you're a for-profit company, it's your job to advocate for the bottom line. OTPs, there's an increasing private equity presence. They're gonna try to maximize profit, and they're trying to do so is getting a lot of people care who wouldn't otherwise have it. Like, that's the profit incentive. And what Hamilton and Madison said is that factions are out there, and they're gonna try to distort the political process. And of course, they talked in the Federalist Papers about mercantile factions and text, but OTP factions, oil producer factions, academic factions, like, that's going to be out there. And their solution, which I, am sympathetic to because I'm a law professor, I guess, is to try to structure the decision-making to kind of channel the role of factions, either to mitigate their ability to distort or to kind of get rid of it or channel it productively. That's another reason that I do not like our current model of reform here, where you have to get both SAMHSA. That if, the lobbying literature is all about veto gates, much easier to lobby and get a no than to lobby and get something through. And so currently, if you want to stop reform, you can stop the congressional proposals. People, we're going to fix the whole nation with one statute. Easy to stop that. Easiest thing in the world, right? Or if you're going to get a regulatory proposal that has to go through SAMHSA and DEA nationwide, you just need to stop at one of those points, or probably up in OIRA or somewhere else that you can't even see. So it's tailor-made for a faction with a vested interest in the status quo to be able to preserve the status quo. Whereas if you switch to a model where we're doing changes on a geographic basis or a regional basis, something like that, then first, you go to a state that has no OTPs in it and you have them fight for it, right? That argument's going to be a lot harder, right, for the OTPs, and their interest is going to be a lot smaller because actually, and that's my last thought on this, they don't, the Massachusetts OTP they've got an interest in Massachusetts, but they may not care that much about Oklahoma. And so they may not participate in that fight unless their interest group, their lobbying organization is present. And then my last thought on that, which I'll leave you with is, we had an antitrust doctrine, and it's under the antitrust laws where you can go at a trade association among competitors and say that that is an antitrust violation. But the Supreme Court said it in the Noor-Pennington cases that that's not an antitrust violation. That's why Google and Meta and Snapchat can all lobby together against public health, regulation. But that's just a precedent based on interpretation of the Sherman Act that is not essential. So if someone were advocating on this, I'd be like, make sure you're thinking about bringing an antitrust case against the trade association if you think they're overstepping their lines too, and at least try those precedents out.
Well, just one thing real quick about policy change. So the literature does tell us on policy change, the most effective way to get it, insofar as lobbying groups are concerned, is actually coalition building. So looking at hundreds of instances of policy change across the US, researchers were able to identify that actually what was most influential, the variable that seemed to be most influential was the number of organizations that supported it. But not only that, the change, the diversity of organizations that supported it, as well as if folks that are higher up in agencies support the change as well, federal agencies, state agencies. So that coalition building, I think, is key.
Well, I think the strongest lobby would be the patients. I've got 5,500 people every morning, 5, 6 a.m. driving long distances to get their daily dose. But as we know, these people, they're trying so hard to stay in recovery that while they're better organized than they were 10 years ago, then, I love the idea of the recovery community, millions of people rising up and saying, no, we need to improve access. That could happen, but not without a great deal of effort.
That's great. And so and to Lee's point too, the way people communicate affects how they come together. And so Twitter and Blue Sky were having a role in organizing, and they've kind of faded out. Increasingly, it's group chats, and then increasingly big group chats through like WhatsApp and Signal and the like. So, wouldn't it be nice if there were a WhatsApp and you got 5,500 people in Maine, and they've got on their phones the same chat with 60,000 other people from across the country, and then they can share about things that are happening and also share about challenges and successes and the like. So that's a question of who's got a lot of funding for organizational development and that.
Not necessarily. The most successful grassroots organizing in changing access to methadone and other types of treatment occurred in Europe with drug user unions. And there's some great documentary histories that are on YouTube that were recorded during the pandemic of some of these early activists and how they created junkie bonds, engaged with legislators. And these were people who were actively using drugs, who were able to change access, help push for policy change. So it's very possible. Now, agreed, there's different governmental structures in Europe and in the US, and there's different norms. But they did not have an influx of capital to create those movements.
That's awesome to lead.
Any other questions? All right. Well, thanks again. That was wonderful.
Thank you for having us.
Awesome. And our students will get to meet you in person at some point. Beginning with our Housing First and Mandatory Treatment panel. We have one of our speakers is online. Can we make sure that is she here? So Chan Kemper, who I'll introduce first, she's going to speak last in our panel. Chan Kemper is the Deputy Mayor of Law and Compliance for the city of Louisville, Kentucky. She's also the Deputy General Counsel to the Mayor, where she provides executive leadership on law, governance, procurement, and compliance issues. She's a licensed attorney with over a decade of experience in legislative advocacy. We're also joined by Stephanie Noblet, who's a senior legislative attorney at LAPA. LAPA stands for the Legislative Analysis and Public Policy Association. There, she specializes in the intersection of science, health law, and addiction policy. She's also a former clinical toxicology lab scientist. Ask her what that means. And she researches overdose fatality review teams, drug screening, medication for addiction treatment, and overdose antagonist access. And finally, we're joined by Jennifer Mathis, who is an attorney and the deputy director of the Bazelon Center for Mental Health Law. She's been there off and on since 1999. She's also served as a Deputy Assistant Attorney General in the U.S. Justice Department Civil Rights Division and has litigated numerous community integration cases nationwide. Each one of these speakers have been great partners to us in the work that we've done in O'Neill on disability work and addiction. And so I'm really glad that they're going to be talking about this very timely topic. And Jennifer Mathis is going to go first. Thanks.
Yeah. So unfortunately, you picked a Luddite to go first, and so I'm not sure I'm going to be good at doing the slides.
Yeah, we can advance your slides
Okay.
for you. Just tell us when.
So, yeah, actually, if you can go through the, well, let's see if I can bring it up.
Look like it's working.
Right. Okay. So I'm going to talk a little bit about this executive order on ending crime and disorder in America's streets that came out, that was issued by the president July of last year, because that I think has had real significance for mental health and substance use disorder policy over the last year. It has really been a driving force of a lot of agency action. And so it's something, maybe you may be somewhat familiar with it, but I'm going to go through some of the key highlights that are in this executive order that have sort of had significant implications for law and policy, and kind of talk about where it leaves us So I will start with a couple of the sentences from the purposes section of this executive order. I would say that, the fact that the executive order is titled Ending Crime and Disorder, and what it is about is mental health and SUD and homelessness, is somewhat telling. I think the overall thrust of the executive order, I think it's fair to say, is to sort of essentially equate, not exactly equate, but say that the homeless population is overwhelmingly people with mental health disabilities and addiction, and that they are responsible for a lot of the crime in urban areas and elsewhere, and that we should stop doing everything that we have been doing in terms of how we address homelessness and mental health and SUD, and that we should be sweeping people off the streets and using civil commitment processes and outpatient commitment in order to basically, for civil commitment, it would be locking people up. For outpatient commitment would be sort of using sort of the specter of locking people up and forced treatment, essentially to get people to comply. This is really an about face, a sort of 180-degree turn in policy from where we have been and where we have, what the goals of mental health and SUD systems have been overall, I would say. So it is significant for that reason. I think the most probably extreme pieces of this executive order are found in the purposes section. I think some of what's in the purposes section is much more extreme than what's actually in some of the rest of the executive order in the text, but I think it is worth highlighting because they are part of this messaging. And so I had highlighted the beginning sentence of endemic vagrancy, disorderly behavior, sudden confrontations, and violent attacks have made our cities unsafe. And shifting homeless individuals into long-term institutional settings for humane treatment through the appropriate use of civil commitment will restore public order. Now, long-term institutionalization is something that used to be common in our mental health service systems, and there was a very deliberate shift away from long-term institutionalization over past decades with the recognition that the reason we use long-term institutionalization is we didn't have a community-based service system. And what we had was kind of an end-stage crisis-oriented system. And so people went into the hospital and, sometimes they came out, sometimes they didn't, and sometimes people were warehoused. But we had gigantic hospitals that were, serving thousands of people in a facility, and we're not providing quote unquote treatment, we're really providing custodial care at some point. That maybe at the beginning there was a period of time when people were getting treatment, and then after a period of time you're not providing treatment anymore, it's just sort of warehousing. And so that was where we came from, and I think hospitals are still a significant part of our system. We still use inpatient commitment. It is a tool that should be rare, but we don't have always a better alternative when somebody is in really acute crisis. We are moving towards alternatives that are kind of crisis stabilization settings and things called living rooms and other places that can be alternative peer respite. But we still have an inpatient commitment system, but it is supposed to be for short-term acute episodes. So the idea of kind of going back to long-term institutionalization would be very significant. That doesn't seem to be really reflected in the text of the order itself in terms of the obligations it imposes, but it is telling that it is kind of here in the purposes section. And so one of the things that it does is direct the Justice Department to seek reversal of judicial precedents. I don't know if people can read this if it's big enough, but you have the materials, I think. Termination of consent decrees and reversal of judicial precedents if they impede, quote unquote, the US policy of encouraging civil commitment of people with mental illness who are on the streets and who can't care for themselves. And so why is it that an executive order would seek to direct the DOJ to not enforce the law, but try to reverse the law, which is an unusual thing for an executive order to do? It is because you couldn't do these things with the current law because there are protections in place. You can't just stick people in institutions if they don't meet the standards for civil commitment, and you can't keep them there for long periods of time if they don't meet the standards for civil commitment. And so that is why I think this executive order is talking about the reversal of judicial precedents. I would say that there really are not, having been at the Justice Department, there are not really many opportunities for the Justice Department to do this because they don't have consent decrees that really are about civil commitment. The only things that I can think of are the civil division at DOJ had a couple of civil frauds, had settlement agreements with some hospital chains that had committed fraud and kind of sweeping people in sort of fraudulently through a commitment system, and paid a lot of fines for doing that and agreed to change policies. Are they talking about getting out of the settlements? I don't know. I doubt it. The Civil Rights Division does not have settlement agreements. They have settlement agreements and enforcement of the law that really points in a different direction because the law really in the ADA, the Americans with Disabilities Act, says that you have to, state and local governments have to serve people with disabilities in the most integrated setting appropriate. So it sort of points in the opposite direction. It is about sort of integration and inclusion and not sort of sweeping people up into the civil commitment system. But none of the Olmstead cases, Olmstead is the Supreme Court case that laid out that this is what the ADA requires. None of those cases, none of those settlements limit the ability to civilly commit people. What they do is they require jurisdictions to provide the services in the community that people need. And when you do that, there are many fewer people who end up civilly committed and who end up hospitalized. And the hospital census tends to go way down when you create the community service systems that are needed. But there isn't a very clear role for DOJ to terminate their consent decrees pursuant to this executive order because they don't really have consent decrees that sort of impede civil commitment. And it would be odd to tell the government, well, you need to stop providing the community services, get out of decrees that require states to provide community services, because what we want is for people to not get the services they need and to decompensate so that they can go into the hospital so that we can rebuild our hospitals and pay huge amounts of money and have a bad service system. So it is a little odd, but that's what the executive order says. And then finally, with respect to the Justice Department, it directs them to use technical assistance and grants to promote quote unquote maximally flexible civil commitment and institutional treatment. And I would say with respect to this, just that this is kind of a direction that our service systems have gone, or our state laws have gone anyway, is to lower and lower and lower the standards for civil commitment over the years. And so I'm not sure that there is that much further for them to go, at least on the mental health side. I think on the SUD side, there are a lot of changes happening, but frankly, most states at this point have what's called a gravely disabled standard, where you do not have to be imminently dangerous in order to be committed. That gravely disabled means that you can be civilly committed simply if they think that you cannot survive safely in the community. It's supposed to be with help. Yes.
Yeah, it might be kind of dumb. I'm an anthropologist, I don't know much about law, but doesn't it kind of, the civil commitment idea goes against the idea of habeas corpus?
Well, yes, people have occasionally brought habeas claims to get people out. I think it has been probably more effective, instead of trying to bring those claims, to bring claims under ADA, which is sort of, you're looking at a whole service system and how the whole service system works as opposed to like one individual. But yes, sometimes when people claim they have been wrongly committed, they might appeal within a commitment proceeding, or they might bring a habeas claim So yes, I mean, the idea is obviously you shouldn't be confining people. The state should not be confining people unless it is actually warranted. And what the Supreme Court has said, and this is the precedent that they're trying to overturn. I think Stephanie's going to talk about it a little bit in her presentation. It's actually a case that my organization had brought to the Supreme Court back in 1975, which is called O'Connor versus Donaldson, which says that you have to be both mentally ill and dangerous in order to be subject to civil commitment, because before that, people were committing their family members. In fact, Kenneth Donaldson was committed by his father and spent 15 years in a state psychiatric facility for reasons that the facility director couldn't articulate and said he forgot. So, I mean, that, is where we came from, and hopefully we won't go back there. So anyway, the next set of obligations I just wanted to highlight from the executive order. Can't read that from here. Can somebody advance it? Thank you. Is that it directs the Justice Department, HHS, HUD, Housing and Urban Development, and Department of Transportation to use their discretionary grants to prioritize jurisdictions that are enforcing prohibitions on quote unquote open illicit drug use, quote unquote urban camping and loitering, urban squatting, or enforcing involuntary outpatient and inpatient commitment. And then similarly, it directs HHS to not use discretionary grants from SAMHSA for substance use disorder treatment and recovery to fund quote unquote harm reduction or safe consumption efforts. Harm reduction, many folks are aware, has been an evidence-based practice that has developed over many years. And so again, this is kind of pointing in a different direction than we have been going for many years. It says, all of these pieces of the executive order that I'm talking about now are all about using the levers of federal money. So an executive order can't really change the law, but it can use the levers of the federal purse and kind of, give money, prioritize for grants, jurisdictions that do things that they want to incentivize. And then it directs HHS to provide technical assistance for outpatient commitment programs. Outpatient commitment, I think you may have talked about some at this conference. I know if you're going to talk about that some in your presentation, but it has been around on the mental health side for a long time. I think it is starting to expand to SUD, but the theory behind outpatient commitment, for anybody who hasn't been exposed to it, is there's a court order essentially that directs that the person comply with the treatment regimen, with the idea that if you aren't complying with your treatment regimen, that you can be hauled into court and potentially civilly committed inpatient. And this is my editorial commentary on outpatient commitment. It's premised on the idea that it's about people who have impaired judgment that is so impaired that they can't make decisions about their own care because they lack the judgment to do that because they're pretty out of it, given either mental health or SUD. And the theory behind AOT is that it's premised on what's called the black robe effect, which is that if you have this piece of paper that says that if you don't comply with your treatment plan, then you might be subject to inpatient commitment and locked up, that these people who are so impaired in their judgment that they cannot be trusted to make rational decisions suddenly gain insight and rationality and make decisions appropriately and comply with treatment because they don't want to be hauled into court and civilly committed. So
Or assisted, as the language says.
assisted outpatient treatment, it has been, it used to be called involuntary outpatient commitment, or IOC, and then at some point its proponents rebranded it as assisted outpatient treatment. And I remember a senior mental health official from New York saying, calling involuntary outpatient commitment assisted outpatient treatment is similar to calling armed robbery assisted divestiture of funds. So, next slide. Thank you. So this, right one? I can't, no, I'm one back. Sorry, can we move one back? Sorry about that. I can't see from here. So the executive order also directs HHS and HUD to end support for what's called housing first policies, which is where the housing is not conditioned on somebody being able to follow the rules, comply with treatment. Housing first, again, was developed over many years. It was first really, I think, touted in a significant way by the Bush administration, Bush 2, where his housing czar went out and really became the Pied Piper for housing first. And it had bipartisan support for many, many years across administrations until recently. And now it has kind of become a partisan issue in a way that never had been before. It seems there's kind of a set of folks who've tried very hard to make it a partisan issue, but there is a mountain of research supporting housing first. And, the idea being that if the best we can offer for people who aren't able to comply with treatment, aren't able to follow the rules, is that we put them back on the street, we are not well serving the people who most need services. Housing first has enormously successful outcomes. Something like 95% of people in housing first remain housed, and compared to programs that are not housing first, where far fewer people remain housed for obvious reasons. So make of this what you will, but we are kind of going to Superman with red sun instead of Superman with yellow sun. Sort of the world looks different. So it also directs HUD to take steps to require funding recipients to increase mandates on that people with SUD or mental illness participate in treatment as a condition of receiving the housing. This is basically the flip side of not funding housing first, funding housing that is conditioned on people complying with treatment. And so these are kind of the biggest pieces of the executive order. These last pieces are, I think, the ones about discretionary funding that have had the most impact, or that are having the most impact. And I'll talk a little bit about the litigation under one of them. I would just say, next slide, that the important principles to remember. Wait, I don't have one that says executive orders do not override statute. Thank you. Okay, thank you. The executive orders, as he said, are not kind of, they don't change the law. They can change government behavior within the parameters of the law. And this executive order it recognizes that. And there are pieces that say, within the bounds of existing law or things like that. But the law still is that the ADA applies. As I talked about, the Supreme Court's Olmstead decision that prohibits unnecessary institutionalization, says you have to serve people with disabilities in the most integrated setting appropriate, still applies. The 14th Amendment still applies. O'Connor versus Donaldson, putting limits on the use of civil commitment. And so it is just important to recognize that this exists within that framework. And next slide. Now I'm getting to HUD. So this is the piece that is, I think, the subject of the most litigation. The biggest thing I think that happened within the federal government implementing this executive order is an effort by HUD to take one of the largest housing grants, the Continuum of Care funds, and condition the receipt of the funding on a lot of conditions that were never in the program before, and essentially to really shift this program from funding permanent housing to funding mostly transitional housing, meaning that most of the people who are currently in housing that is funded by Continuum of Care would lose their housing. It was estimated something like 170,000 people at least would lose their housing as a result of this. There were various parts of the notice of funding opportunity. It was pretty chaotic. They had a prior notice of funding opportunity that had already gone out, and then they rescinded that, and they waited for a long time, and then at the last minute, they put out this new notice of funding opportunity that really turned the world upside down and had all of these different conditions and said you have to have the right gender ideology and you have to have laws that have this and that with respect to involuntary commitment. One of the priorities for permanent supportive housing excluded people with mental health disabilities and substance use disorders from the priority groups for permanent supportive housing, which seems odd if your view of homelessness is that it is primarily people with mental health and substance use disabilities, but there we are. And so, this NOFO was enjoined by a federal judge in Rhode Island. That litigation is still ongoing, but she just issued a very short order. It happened quickly. There's more litigation to come, but HUD was sued both by a set of states as well as by National Alliance to End Homelessness and a bunch of nonprofits and a bunch of counties. And those two cases got essentially consolidated. And so right now, the new NOFO is enjoined. They made changes. They did not make the judge very happy because a couple hours before the hearing, they announced that they've changed the NOFO and they're rescinding it and they're going to change it. And so the judge was not amused, but she issued an order anyway enjoining it. And they have since changed it. There will be litigation about the new one, which hasn't changed that significantly for the most part from the old one. But right now, there's also legislation to extend the contracts from the old NOFO, which Congress has now passed. And so it at least stabilizes that housing for another year or so and gives people time to deal with the changes that are happening. So next slide. So I would just end by saying that there are a lot of considerations to think about at this moment in time. If you are going to have an executive order that is aiming to take away people's housing, if they cannot comply with treatment, it is going to take away a lot of housing from people with mental health disabilities, from people with SUD, the very populations that the executive order is aiming at. And while the executive order says that, it is aiming at long-term institutionalization, this is a moment in time when no state is going to be long-term institutionalizing people because Congress passed the One Big Beautiful Bill Act, cutting $1 trillion from the Medicaid program, imposing Medicaid work requirements such that every state and every county is facing major budget shortfalls, is making cuts everywhere they can in their disability service systems and their mental health and SUD systems. So this is not a time that they're going to spend $1 gajillion on institutionalizing people just because that would somehow be better, according to the folks that drafted the executive order. And so you're going to have people cycling, basically going in and out and in and out of hospitals, ERs, jails, shelters, all the most expensive interventions because we aren't providing sufficient community services, and apparently we're not going to do that so much anymore. So these are all part of the moment. These are all things to think about. The HHS reorganization and proposed cuts to SAMHSA programs, some of that did not happen in the end, at least with the budget bills, the appropriations bill that Congress passed. However, a lot of what's happened at SAMHSA already happened. And so some of what was there is not going to come back very easily. And so that is going to have an impact as well. The part of SAMHSA, the community support programs branch that kind of gave guidance every year, that did all the toolkits for state mental health systems on what the core services are and what they should look like and what the evidence-based practices are. They don't exist anymore. And so I don't know if they will come back or not with this budget, but all of these things make it very, very difficult for implementing the kinds of things in this executive order. Also, as I said before, the Supreme Court precedent still exists, the Olmstead case, that obligation still exists. So whatever states do, they still have to comply with the ADA and Section 504. Same with the federal government. The VA is just now the subject, as of about a month ago, of a court order from the Ninth Circuit saying that they violated Olmstead by failing to provide community-based supported housing for homeless veterans with mental illness. Where does that leave us? We are in Superman with Red Sun, and I think the Enterprise is getting back to Yellow Sun. So with that, I'm going to turn it over to, I think it's just Stephanie, or, yeah, I think.
One second.
Clicker challenge.
I want to use the clicker.
Since tomorrow morning.
Such a big.
Clicker down for a second. I think it's,
Well, hi, everyone. My name is Stephanie Noblet. I'm a legislative attorney with LAPA, which is this big mouthful here. I was asked to speak on involuntary commitment. I know involuntary commitment is a very controversial topic. I'm not here to speak in favor or in support of involuntary commitment, nor am I here to speak out against it. I'm simply here to talk about how it is a tool that states are using and might be using more frequently, as we talked about, and also give you the legal landscape of what involuntary commitment currently looks like across the US. Next slide, please. So just before I dive into the main topic, I just wanted to talk a little bit about LAPA. For those of you that are unfamiliar with us, we're a 501c nonprofit that does legal and legislative research within the areas of criminal justice, public health and safety, and substance use disorders. We've been the recipient of ONDCP's Model Acts grant program since 2019, and all of our work products, which includes our model laws, 50 state surveys, and fact sheets, are all publicly available on LAPA's website for anybody to use and access at any time for free. Next slide. All right, so let's dive into the main topic. So what is involuntary commitment? So involuntary commitment is a civil legal process through which a judge can order an individual who meets certain criteria to be put into treatment against the individual's wishes. Involuntary commitment is not drug court. It's separate from that. Somebody would need to have been arrested and charged with a crime for that. This is a completely separate thing, and it's judged under the civil courts. Traditionally, involuntary commitment was used as a process for mental illness, but now we're starting to see it used more and more for the treatment of substance use disorders. States started to really enact involuntary commitment laws specific for substance use disorders in about the 70s and 80s as the war on drugs really started to ramp up. Now, there are two legal justifications for involuntary commitment. The first is parens patriae, which is the legal doctrine that allows a state to act in place of its citizens when it feels like the citizen cannot act in their best judgment or on their own behalf. And the second is the state's police power, which allows the state to limit individuals' autonomy when necessary to protect public safety and prevent harm. Next slide, please. So as Jennifer briefly mentioned, there's two Supreme Court cases that govern involuntary commitment. The first is the 1975 case O'Connor v. Donaldson, which established the dangerousness standard, which I'll get into more later. But essentially what this case said is that it's unconstitutional to confine an individual that is not dangerous. And once that individual, if they are committed, as soon as they are no longer a danger to themselves or others, they need to be released from that commitment. The second case is the 1979 case Addington v. Texas, which established that the clear and convincing evidence standard is the legal standard for these involuntary commitment cases, which Sazula actually talked about earlier, is that middle standard between the civil standard of preponderance of the evidence and the criminal standard of beyond a reasonable doubt. All jurisdictions use the clear and convincing evidence standard for civil commitment cases, with the exception of Kentucky. Kentucky actually uses beyond a reasonable doubt. Next slide. So as I stated, involuntary commitment is very controversial. It's always been controversial. I think it always will be. Involuntary commitment for substance use disorders is actually then even more controversial as opposed to involuntary commitment for mental illness. And that's in part because it's so much harder to draw the line of when somebody should be committed, if at all, for a substance use disorder, as opposed to a mental illness. So if you think of somebody with psychosis and if they've lost all connection with reality, that's something that can be more easily determined, and they know where they are and they've lost all connection with space and time. Whereas drugs, nobody's using drugs 24/7. There's always going to be a period when they're off them, and people use drugs in a variety of ways at a variety of risk levels and for a variety of purposes. So it's hard to know when to make that decision of, okay, we're going to fully commit somebody because we believe that they've lost control. So people that support involuntary commitment, their main argument is that it's a tool for friends and families to intervene in a loved one's life when they really fear that the individual is going to die without any assistance and that all other means of intervention have failed. They also believe it's a way to help their loved one without getting the criminal justice system involved. You're not sending them to jail, you're sending them to treatment, but some people will argue they're one and the same. Additionally, they argue that it can help place people on a path towards recovery, which they might not have found themselves on without somebody intervening on their behalf. Those that oppose involuntary commitment believe that it can exacerbate trauma, it fosters mistrust among family members and also the healthcare system, and that it makes individuals less willing to seek help in the future, and that can result in potentially poor long-term outcomes. And also that it's against the core medical principles of patient consent and autonomy. I'll also note here that there is very little research on involuntary commitment, both for mental illness and SUD, but more so for SUD, less research. And that's something that's desperately needed because at this point, we really are unsure of whether this is actually helping people or if it's just furthering. Next slide. So we already talked about the executive order, about how that explicitly mentions civil commitment. I was also glad that you mentioned how it kind of talks about mental illness, but it was also my read that mental illness is used as this catch-all phrase for homelessness and substance use disorder. But then on the state level, last year, we also had former Mayor Eric Adams talking about involuntary commitment for substance use quite regularly. That was picked up a lot by the media. Currently, New York does not allow for involuntary commitment for substance use disorder, and he was trying to lobby the state government to make that change. That wasn't something that happened, but we'll talk a little bit more about that later. Next slide. So again, I'm not here to talk in for or against involuntary commitment, but actually to discuss some of the research that I did on the topic. So in 2024, I conducted this large research project looking at the involuntary commitment laws of all 50 states, DC, and the US territories with a specific focus on involuntary commitment for substance use disorders. And all of that is available in this beautiful 50-state survey that's available on our website. So I'm going to go through some of the things that I found through our research and comment on some of the themes. I'm not going to be able to highlight everything that I saw or felt is necessary to talk about, but I'll bring up a few key things. Next slide, please. All right, so all 50 states, the District of Columbia, and all territories allow for involuntary commitment, and they have an involuntary commitment law on the books. Now, where it gets a little complicated is that of those, 34 states, the District of Columbia, Puerto Rico, and the U.S. Virgin Islands allow for involuntary commitment for the primary diagnosis of substance use disorder. This means that if the individual, the respondent is what they're called, has a substance use disorder and their loved ones or whoever is filing the petition is worried about their drug use, that can be the primary basis of the petition for involuntary commitment. In the remaining states, you need to have some sort of co-occurring mental illness in order to be committed. So you can have an SUD and be committed, but it can't be the basis of the petition. It needs to be some other mental illness that is the main primary basis of the petition in order to qualify. And then Rhode Island, because there always has to be one outlier state, Rhode Island allows involuntary commitment for individuals with a primary diagnosis of alcohol use disorder, but for substance use disorders involving other substances other than alcohol, you would need a co-occurring mental illness in that case. Next slide. All right, so let's talk about the criteria for involuntary commitment. So ideally, if you're involuntary committing somebody for a substance use disorder, the substance use disorder should be severe. And this was something that Dr. Einstein talked about yesterday morning. So severe is actually a diagnostic criteria or a category defined in the DSM. It's not just a judgment call. You have to meet certain criteria. That's the highest level of diagnosis for an SUD. We want to make sure that when we're using involuntary commitment for SUD, that it's only in very specific, serious situations. So just using substances alone is not a justification. Just having a diagnosis of substance use disorder alone isn't a justification. And neither is the risk of overdose, because anybody taking any substance could overdose potentially at any time. Now, additionally, we want to make sure that just the refusal to seek treatment or participate in treatment by itself shouldn't be a reason or a justification for involuntary commitment. And some states actually specifically mention that within their laws. Now, we talked about earlier how the O'Connell case established the dangerousness standard. So essentially, in order to be committed, an individual must present a danger of harm to themselves or to others. But how danger is defined it's not really well defined, and it kind of varies depending on the state. So some states define dangerousness pretty broadly, where there are others is more specific. So critics of involuntary commitment argue that dangerousness should be limited to a grave disability of physical harm, imminent physical harm to self or others. But some states allow also the risk of emotional harm as well, in addition to physical harm. And then Jennifer also mentioned how things have been expanded recently to also include this possibility of having a grave disability or a serious deterioration as also being a criteria for meeting the eligibility requirements for involuntary commitment. Next slide. So I've actually pulled out some language from a few states to use as an example, so we could go through and see just how different these states are and compare. So the first one I have here is Casey's Law from Kentucky, which I wanted to mention because Chan is on the panel. She's in virtual world, but as we can see here, so the language, it doesn't mention a severity of the substance use. It just says substance use disorder. It doesn't specify that it has to be severe. It also it mentions the threat of danger to self or others, but it doesn't say what that danger is, whether it's physical danger or includes emotional danger as well. And then we see it says it presents an imminent threat of danger, which is great, but then it goes on to say, oh, or a substantial likelihood of threat in the near future, which kind of, anything could happen in the near future. I think a lot of people would argue that that's too broad. Next slide. Then I have Marchman's Act from Florida. So again, Florida doesn't mention a severity level of the SUD. Florida is one of the states, however, that says the mere refusal to receive treatment and services is not enough to commit somebody. Florida, 2A here would be an example of the state implementing this grave disability standard, while B here would be the dangerousness standard. And while it does say, it doesn't also mention it does say, physical harm to himself or others. So it does establish that it's physical, but it doesn't necessarily provide the imminence for the threat. Next. Then I have Massachusetts here. So Massachusetts, an individual can be committed if there's a likelihood of serious harm, which is defined in statute. So again, it doesn't say anything about the severity, but it does mention explicitly physical harm. 1 and 2 would be the establishment of risk of harm to self or risk of harm to others. But 3 here, this language to me reads a little broad, especially the language unable to protect himself in the community. That doesn't really mean much to me. That could potentially be somebody being unhoused. And I'll also point out that this statute uses ors instead of and. So this third criteria could be the main justification under that likelihood of serious harm. So that could expand the use. And Dee yesterday, who's not here today, but she had mentioned that Massachusetts is the most, or if not the most used involuntary commitment law for SUD in the country. And unfortunately, they also do allow people to be confined to jails or correctional facilities. Next. And then the last one I have here is from New York. So New York does not allow involuntary commitment for a primary diagnosis of SUD, but I wanted to mention this one because of the language in this subparagraph 3 here, which was actually just added in August 2025 by an amendment. So if you read this here, so this clearly allows for the involuntary commitment of people that are unhoused. So are unable to provide for their basic needs, shelter, safety, food. So that is going to greatly expand the use of involuntary commitment in the state. Next slide. All right, so now let's talk about who can petition for involuntary commitment, which again, like most things in the involuntary commitment world, depends greatly on which state you are in. So in 26 states and 4 territories, any adult person can file a petition for involuntary commitment against any other adult. In the states that do limit who can file a petition, it's usually limited to relatives, conservators, adults that are related or that live with the respondent. So that could be like a roommate or an unmarried significant other, healthcare practitioners and behavioral health practitioners that are taking care of the respondent, and law enforcement officials. The inclusion of law enforcement officials is pretty controversial. Some people argue that they should be able to file petitions because in some situations where the person has no family or maybe no access to healthcare, the law enforcement officer may be the only person to interact with the person and help them seek help. And then others argue in the opposite, that law enforcement, they're not trained to pick up these things. They're only seeing people in a small snapshot of time, and they're not aware of the person's large scale or long-term behavioral patterns. And so there's, pros and cons for the inclusion of law enforcement. But there's concerns that, it could be an abuse of power. Next slide. So then again, when we're talking about who can file, we also have this idea of the false petitions, that somebody could potentially file a petition with in bad faith to get somebody committed. in 24 states, they specifically delineate within their involuntary commitment laws a penalty for filing a false petition, which can range from felony to a misdemeanor. In the remaining jurisdictions, that doesn't mean that there's no penalty, that you can just file whatever. It's just likely included in some other state law. It's just not specifically mentioned in the involuntary commitment law. Next slide. Then we come to the length of commitment, which is very wide ranging. So somebody that's involuntary committed, depending on which state they're in, could be committed up to 15 days to up to a year. Some states also don't even mention the maximum length within their commitment. You're just there till you're not there anymore. And a few states have different commitment levels for outpatient treatment as opposed to inpatient treatment, with outpatient treatment usually being a longer maximum commitment length than inpatient. Next slide. And then the majority of states, if after you reach that maximum commitment length, somebody, either the physician or the judge, depending on the state process, determines that you're still in need of further treatment, your petition can be renewed for another maximum commitment length without the petitioner having to go through the whole petition and hearing process again. So depending on the state, that's usually, you can have 1 or 2 renewals before you have to start the whole process over again. And additionally, the maximum length of commitment for the renewal is usually the same of whatever the initial period was. So if it was initial period of 90 days, the renewal would also be for an additional 90 days. Next slide. And then the last thing that I wanted to touch on today is the cost of treatment. Whenever I hear people talk about involuntary commitment, especially in the political space, you know, they don't talk about who's actually going to pay for this treatment. Like if somebody is, you know, in the hospital for 90 days, that's going to rack up quite a bill. So who's going to pay for this? Who's responsible? Is it the petitioner? Is it the respondent? You know, is there insurance involved? Does the county or state have any obligation to pay? And what about where the petitioner or where the respondent receives treatment? Is there a difference if they're held in a public facility versus a private facility? Next slide. So again, like I did before, I pulled some actual examples from states to demonstrate just how much variability there is. So in Arizona, it's the patient that's responsible for the treatment unless they're indigent. In such case, the state would pay. But, you know, of course, if they had insurance, they can use the insurance to cover all or part of that. But when we're dealing with people that are at the level of needing to be committed, they probably aren't keeping up with their insurance. In Florida, if the respondent wishes to go to a privately funded treatment center, they have that option. But in that case, they're fully responsible for the cost, either themselves or somebody on their behalf, such as a family member. So again, insurance could potentially play in there, but it makes it a much more expensive option to go to a private facility than a public facility. Next slide. In Kentucky, it is actually the petitioner that is responsible for the cost. And actually, when they're filling out the petition, part of the petition is them showing that they have the financial means to cover the cost of treatment for the respondent. So, you know, this financial means test, including that as part of the petition, yeah, that can help reduce the possibility of false petitions, but then that's also limiting the use of involuntary commitment to people only with certain financial means. And then finally, I have here in Washington, the respondent is responsible for treatment unless they can show that it would be a substantial hardship for themselves or their families. And if such case, then the county in which the hearing and where the involuntary commitment hearing was held would be responsible. Next slide. So finally, I just wanted to briefly mention that last year I worked on an involuntary commitment model for SUD. The model itself is not saying, hey, this is great, everybody should use this, but it acknowledges that this is something that is being used by states and that there is a lot of variability right now, which is making things a mess. So the ultimate goal was to provide some consistency among states and also to allow for the research into involuntary commitment so we could have more knowledge on what this is actually doing. So in drafting this model, we consulted with a variety of subject matter experts from a variety of backgrounds, including people that were both for and against involuntary commitment. So we weren't just looking at one side. The model isn't currently available on our website, but should be available soon. And sorry. And yeah, so the model is out there, but we're hoping that states can adopt this so we can start to have, if this is going to be used, that it's done in a way that provides the respondent with as much autonomy as possible, but also make sure that, we're balancing public safety and also the rights of the respondent. Next slide. So thank you all so much. This is my email up here. You're welcome to email me. If I had more time, I would go more in depth into the model and what decisions we made and why. But you're welcome to email me, and you can also check out all our work products at legislativeanalysis.org. And thank you for having me.
All right. We have to enter Chan. Chan, can you hear us?
I can. Can you hear me?
We can, but we can't see you yet, so we'll
Uh-oh.
wait.
I'm on camera.
Yep, we just have to do our little magic.
Okay.
Somebody else, when I say we, is doing.
Somebody who knows what they're doing.
Somebody who knows what they're doing. You've been in my class, Peter. And actually you can share your slides.
Okay, wonderful. Okay. Can you see my screen?
Yeah.
It does back there.
Well, we see them on one of the
Yeah, but,
in front. Just not on the left.
we're working on it.
Right.
Okay.
But you're still a disembodied voice.
I have my camera on. Give me 1 second. I'll see if
You probably
there's
want to,
something
if
on.
you could do your slideshow, so it's the entire screen.
Yes.
And then you can start and we're gonna figure this out.
Yeah.
Okay. Give me 1 second. I will make this my entirety of my screen.
Slideshow mode.
Slideshow mode, yeah.
Nothing makes me feel older.
Slideshow
Then-
right there.
Did I miss it? View.
See up at top, it says slideshow.
Oh, it's being covered by my Zoom screen. Give me 1 second.
It's me every day.
Yeah, there we go.
Me every Friday.
No.
5.
From beginning.
All right. Can you see? Everything looks good? Okay, wonderful. Thank you so much. I am Shan Kemper. I am Deputy Mayor of Law and Compliance for Mayor Greenberg, who is the mayor of Louisville, Kentucky. I'm also Deputy General Counsel. I'm so glad to be here today. And Stephanie, thank you for the shout out to Kentucky. I worked with Stephanie at LAPA a few years ago. How are you? And so it was nice. I wish I could be there, but I'm happy to be here virtually. And my presentation is a little bit of a pivot from the earlier discussions in that I will be talking about behavioral health, but more from the perspective of housing and homelessness, and essentially almost like a case study of system measurement and pathways in a post-grants path. And I'll explain what that means in just a little bit. Essentially, this presentation is going to be discussing what enforcement of grants passed, and you'll learn about Kentucky House Bill 5 looks like currently, with the premise essentially that enforcement of these laws without exits just creates more issues and problems and what Louisville is doing to address this. So I don't know how many of you are familiar with what a PIT count is. Every year, thousands of wonderful volunteers and individuals who work in housing and homelessness flood the streets of every major city in the United States, and they do a count of unhoused individuals throughout the United States. There are a lot of arguments as to why this is not the best way of counting homelessness in the United States. Point in time, it's essentially point in time. But this is currently the way the federal government does it. And in 2024, we had 771,480 people counted as homeless at that point in time. That includes 150,000 children. I give you this number because it is important context to where we are currently in this country regarding housing and homelessness and the laws that impact that. So when we talk about public order, when we talk about unsheltered homelessness, I'm talking about how a jurisdiction manages a growing population with high needs, limited housing inventory, and legal frameworks that increasingly push the problem into the enforcement lane. In 2024, the Supreme Court of the United States passed down a decision. We call it Grants Pass. And when I was working at an organization called Community Solutions, my organization actually filed an amicus brief, which is a friend of the court brief, essentially, in Grants Pass, arguing that Grants Pass should be upheld. Unfortunately, the Supreme Court held on June 28th. They ruled 6-3 in Johnson v. Grants Pass that enforcing camping regulations against homeless individuals is not a cruel and unusual punishment. So essentially, local governments can now enforce camping regulations without fear of being sued for violating the 8th Amendment of the United States Constitution. This finding essentially struck down and overruled a Ninth Circuit case, Martin v. Boise. The Ninth Circuit's decision in Martin had led to widespread tent encampments and essentially had found that it was cruel and unusual for cities and local and states and local governments to enforce housing laws or anti-encampment laws when there were not enough beds for an individual, for unhoused individuals in that city. With that overruled, that sort of flooded. There's been a flood of state legislation and local legislation to allow for governments to take down encampments. With that being said, we come to the impact of Kentucky on that. Kentucky's House Bill 5, which passed in 2024, is also known as the Safer Kentucky Act. And it created the unlawful camping framework that cities, including Louisville, must navigate. So KRS 511.110 defines unlawful camping around knowingly entering or remaining in a public area with intent to sleep or camp there, with camp paraphernalia included in that framework. And what that means is the penalty ladder matters operationally. So the first offense is treated as a violation, and repeat offenses or refusing to cease in the first encounter can become a Class B misdemeanor. House Bill 5 also restricts local policies that prohibit or discourage enforcement. So even if Louisville Metro, so just as a side note, Louisville has a mayor, of course, and then we have a Metro Council, which represents the different districts throughout Jefferson County, which Louisville is in Jefferson County. So even if the Metro Council wanted to create laws that would essentially oppose House Bill 5, they can't under state law. That's specifically baked into House Bill 5. Now, it does leave room for diversion programs and service first approaches in how a jurisdiction might operationalize compliance. And there's also a little bit of a broader architecture around the bill in terms of how counties and temporary camping areas can be set up. So essentially, the practical takeaway that I want you to take away from this is that the state has increased pressure towards enforcement, and so has the federal government, essentially, or the Supreme Court, with the passing and grants passed. And then earlier, as you heard from our earlier presenter, we also have the current administration, the Trump administration, with executive orders that essentially point toward, hey, this is how we want you to operationalize how we treat behavioral health issues, how we treat unhoused individuals, which we know often they're a Venn diagram, unfortunately. So the House Bill 5 created, so I don't know if you know this, Louisville is, our mayor is a Democrat. And we have a large population, we have a large group, a large, I guess, economy of individuals and organizations that work to end homelessness and housing in the city, which is a very good thing. That is a very, very, very good thing. However, what that we have butted up against that with that is the fact that we also have a mandate from the state to enforce housing, the anti-encampment laws. This is a core tension: rising homelessness, limited shelter capacity, and the risk that a punitive posture will displace a large number of individuals. And frankly, I will tell you, as someone who worked for an organization that worked to end homelessness and had a very black and white, and I don't think this is a bad thing, but a very black and white viewpoint on encampments, coming to work for a local government where the realities of what that looks like in terms of individuals in encampments and large encampments was very eye-opening for me. And what I mean by that is housing encampments, oftentimes individuals are going without medical care. They are preyed upon by traffickers, and there are actions and crimes happening within the entity. I'm not even talking about outside of the encampment areas, how individuals in that city may view encampments. I'm talking about within encampments. So there's just like a core policy tension there that the city has to navigate, while also being very aware of the fact that these are individuals, these are people's lives. This is where they live, essentially. The component that I think is particularly relevant here is a disproportionate number of unhoused individuals also suffer from behavioral health, also live with behavioral health issues, and they are not getting help at encampments. So as of July 2nd, 2025, there were 425 unlawful camping charges filed in district courts around 30 counties. The largest number of those offenses that were charged were in Jefferson County, which for all intents and purposes is Louisville. So Louisville Metro government is within Jefferson County. So the issue is Louisville Metro Police Department is mandated and was getting calls from citizens, hey, there's an encampment near my home. This person is living outside and is near my home. So there were citations happening, and there was no way to help off-ramp individuals who were getting, citation after citation because they literally had nowhere to go. And that's where we get to a local strategy, which I would call it stability first interventions within our legal and within the legal constraints that we're operating in. So we have the unlawful camping docket. And what this is, I think this is pretty wonderful. And one of the things I'm very excited about is we have a housing court, our homelessness court. The stated goals for this court are to prevent unnecessary eviction and reduce inflows into homelessness, connects tenants and landlords, rental assistance, family, creates a structured lawful forum for problem solving and compliance. So this is in the beginning, we showed my title, Court Connected Pathways. This is what I meant by that. So this is sort of built into our our eviction docket, which is you have your one prong, you have eviction prevention, which helps function as homelessness prevention and reduces downstream public costs, and a court-centered diversion posture, which can mitigate spillover from camping enforcement. But we also have at this eviction, at our homelessness court, we have housing organizations. We have, so for example, CITA is our Spanish language, Spanish first organization that works with immigrants. So they might have a presence there in order to help individuals who may not speak English, may not be their first language, but they received a citation ticket. We have our our homelessness organizations there. So yes, a person may have received a ticket for being unhoused, for the crime of literally being unhoused. But we want to make sure that this is not just something where you're getting a ticket and ramping up a ticket because you literally cannot fix the issue of being unhoused. This helps them prevent a camping citation from automatically becoming a conviction. So that's where we say where there's diversion there. Our first court unlawful camping docket was held in January 2025. So you had your prosecutors, your public defenders there, service providers. And so essentially the prongs of housing navigation, even getting people IDs. Honestly, it's hard. You can't, there's a famous, one of my favorite rap songs. There's a line from Common where he says, how am I gonna get ID if I don't have ID? And that's true. You're not going to get, it's true. You're not going to get a house. You're not going to get an apartment. You're not going to get housing if you don't have identification. So having someone there from the clerk of courts there to help expedite that. Those are all a part of it. And this is not a one-off. We do this, the docket happens on a monthly basis and reflects an institutional effort to sort of build this into our court system. And I would be remiss if I didn't say that people are also continuing to get cited. People are still cited under state law. That is still something that the LMPD will get a call about. Now, if they can divert, they will. If they can avoid citing the person, they will. But it does continue to happen, and that is honestly the reality of it. But the hope is even if that person will show up to the court and show up on the docket and be able to assess services that would help them on-ramp them into housing. And this is where we have housing for good. So it's not just saying, hey, we're going to give you a ticket and then maybe we'll help you get out of that ticket by making sure that you have housing, but like building actual housing, baking that into the work that we are doing to end homelessness in Louisville. And this is working with Home for Good, which is the Mayor Greenberg's, or Housing for Good, Mayor Greenberg's big push to build, I think it's 3,000 homes in the next 4 years, and working with other permanent supporting housing and working with our local entities and organizations, Louisville Metro Housing Authority, which there's AC with partners. So we treat homelessness response like an integrated system with capacity constraints. And to behavioral health, speaking to that with housing, as I mentioned earlier, the Venn diagram of individuals who are unhoused, who are also living with behavioral health concerns or mental instability, there's quite a crossover. So as part of that, part of our homelessness court is trying to get individuals engaged, in touch with, or on-ramped into getting help. And that may look like we have several hospital systems here, having them there, making sure that if someone can get medications, that can be provided for them. So it's a court-centered diversion process, but with the hope that it's sort of like a wheel and spoke. And Stephanie knows what I'm talking about, because we hear that a lot of times with substance abuse treatment, the wheel and spoke system. And that is sort of the same thing here. Is it my favorite thing that the first form of engagement is with a ticket? No, it is not. That's just me. I don't have I can say that honestly, but I do appreciate that Louisville is approaching this in a way where that's not the end all be all. And unfortunately, there are many cities in the United States currently that are grappling with having the enforcement stick, but not the carrot. They've just got the stick and not the carrot. So, I also want to point out, and I would, because I kind of have to, as someone who worked for Community Solutions, which the whole messaging at that organization is that homelessness, we can stop and prevent homelessness a lot easier and on a much bigger scale if we were more interconnected, if there was more engagement between care providers and court systems and governments. Data governance, so aligning data, aligning what the court, who's getting in front of the court, aligning medical services. That's a big push that I am pushing within my organization, within Louisville Metro government, but I'm also seeing it being pushed throughout the system here in Louisville. And I'm just pointing that out because if there's someone in the crowd who is interested in that, I'm happy to get you in contact with Community Solutions, the organization that I work for, because that is their big thing. And I do see the benefit in that. If you know someone, for example, has a mental health issue, but they're also unhoused, having that the ability to access their records or in a HIPAA compliant way, of course, having that ability to assess their records and being able to access other issues that they need, and multiple people being able to do so at the same time or interconnected, it makes a huge difference in getting that person treatment and getting that person housed. So my final takeaways on this is I'm going to start with the third one, actually. We know there's going to be federal pressure down the line from the federal government on how we are treating and approaching not only housing, but individuals with behavioral health issues. I think one of the big things I've come across is making sure that we are documenting everything, that we are in compliance with state law, that we are having, with the system that we are using right now, we are having a noticeable impact on the number of unhoused individuals that are living in Louisville metro government. So we can show that, hey, we don't need to take on bigger commitment, like mental health commitment issues. We don't need to take this on because of what we're doing now works. My second takeaway is use dashboards to prevent reactive policy. So have specific KPIs on what key performance indicators on what you think will come from this. The number of people on our dockets, the number of people who are actually getting help, decision thresholds. Treat public order actions as a managed workflow. So we know that we are engaging with people on the street when they're getting a ticket, offering them service, offering diversion. So treating it in a very ordered and coordinating manner, which goes back to the dashboard issue. It goes back to how keeping track of this. And then I will say I am not as involved in housing and homelessness as I was when I initially started. I am a deputy mayor now, and I am a lot more engaged on other issues, but I still have a lot of just on a personal level engagement with this. And I really do think that has made a difference in terms of the interconnection you see at the housing and homelessness courts in the number of people that they've been able to engage with and treat. And these are the appendix. I'm happy to share this with anyone just on the statutes that I use. And I was about to say, here's my contact information, but I don't think I put it on there. But I'm happy to provide my contact information to anybody who wants it.
Thanks, Jan. We might be able to see you now if you stop sharing your screen.
I did.
Thanks. Okay.
Over
Right.
there, maybe.
I think you can see you over there. Questions for the panels?
I had a question. And I guess it's for you, Jennifer, and for you, Stephanie. I was wondering, Jennifer, if you could speak specifically to the portion of the EO that talks about sex offender registry. And then the second part of that, Stephanie, is what are the similarities between civil commitment for sex offenders versus civil commitment for SUD and mental health?
Yeah, so you have to remind me of the sex offender piece, because it's been a while since I have looked at that, because you haven't, I think I brought it with me. The EO.
Specific was 1997. I think the
But the
decision
piece
was
in
written by
the,
Thomas.
piece in the EO, I think that he's talking about.
Yeah, there's a specific portion that talks about when arresting people who are unhoused, making sure that they're screened through the sex offender registry. That was my question, just about your thoughts on that or concerns.
Well, yeah, I mean, certainly, sex offender registries have obviously made it much more difficult for people to be housed because of limiting where they can be housed, and often that obviously contributes to homelessness. So certainly, sort of focusing on that and making sure that there's a screening process probably impedes the ability to house people more. I'm not sure, though, as a practical matter, it seems like for the most part, people are getting screened out if they're on a sex offender registry because there's enough screening that is happening that they are screened out anyway. So practically speaking, I don't know how much it will change, sort of what happens in practice, but, yeah, I mean, it speaks to like, well, you are concerned about housing being unavailable or people not being able to, it's not the concern about housing being unavailable. It's really the concern. It's all the people. It's not the housing, it's the people is kind of the thrust of the executive order. But, if you're concerned about sort of addressing homelessness, then, there should be something that helps make the housing more available and helps give people the services they need to stay housed and be housed, and just sort of screening people out doesn't really address this problem. So I guess that's what I would say generally.
Yeah, I think that's a good question. I know, full disclosure, I haven't really read any of the involuntary commitment for a lot of times in the laws, they call them sexually dangerous individuals. I know like in some states, you're looking through the statutes and it's voluntary commitment for mental illness, and then the next one's involuntary commitment for substance use disorder, and then you have the sex offender one. So that's like 3 different processes, and they're all kind of siloed. The one big difference would be that the sex offenders that would be through a criminal process, like they've been charged and prosecuted with something, whereas, the SUD, there's not necessarily been a crime committed. So dealing with a more civil-based process as opposed to criminal. But yeah, I can't really answer anything further than that as I'm not really familiar, but thank you.
And I think in general with sex offender commitments, you can keep people for an extraordinarily long time because as long as they're quote unquote getting treatment, the basis for the commitment can continue.
Thank you both.
Thank you.
Question? Stephanie, question for you. For involuntary commitment, do you know who bears the cost in Texas? Is it the petitioner? Just curious. So
I don't know. I would have to look at the 50-state survey.
But
Yeah, I don't know off the top of
speaking,
my
I think
head.
again, like it's going to be the state and the local government for the most part that in most commitments end up paying the cost.
Yeah, I would agree, because most people, even if it lands on like in statute, it says it's the respondent or the petitioner, most people are not going to have the financial means to cover at the very least all of it, maybe part of it. So at some point, it's going to end up with the state. And that's just the cost of the treatment. Then remember, there's also the whole legal cost that's also baked in there as well. So it's a very expensive process.
Thank you.
What happens when people are released from their involuntary commitment? Are they like connected to more permanent housing, or
That's a really good question.
That's
That's a great question.
like they just let them go back to society and say, well, you did it. Great job, everyone. Or do they actually give them the supports that they need to actually take care
Well,
of
that's the $64,000 question, right? I mean, theoretically, hospitals have obligations and as part of the conditions of participation in Medicare and Medicaid, I mean, you have to have discharge planning obligations and, you're not supposed to just dump people. I mean, of course, that happens. It happens all the time. It happens that, there's sort of midnight van dumps that people have a subway token and a bottle of pills, if that, and, and the less there are community services available, the more that's going to happen because hospitals don't want to hold on to people forever. And they shouldn't hold on to people forever. But, theoretically, in many cases, people's continued commitment is not because they really need to be committed, but because there isn't anything available in the community. And so they are still considered dangerous because there isn't any place where they can go and get services that they need. But yeah, I mean, it happens just because practically speaking. It is so bad, in the state of our community mental health and SUD service systems that people are discharged without linkage to appropriate services.
Yeah, and it really depends on where you are. Some states within their statutes require the facility, okay, like within 20 days of release, you need to work on a discharge plan with them and, you know, you need to set up linkages to care.
20
whereas-
days
Well,
after
I don't know,
release, you
well,
have to work on a discharge.
well, like, or not before.
Discharge planning is
Yeah,
supposed to
before.
start
I'm
the day
sorry,
when you're admitted
yeah.
to the hospital.
I
Yeah,
misspoke,
so-
yeah, before the release. But that was one of the things in the model that we required that, you know, you needed to have the discharge plan, you needed to have established, you know, follow-up treatment plan with them and have appointments. If they were on MAT, you needed to give them as much as legally possible, like fill the prescription for them until they can get their next dose. But, you know, unfortunately, it really depends on where the person is and what facility they are and how much they're gonna do to support them once they're discharged.
I think it speaks to this issue that people, I think, assume that, you know, hospitalization is sort of a magic bullet and that if you, you know, and basically what hospitals tend to do is sort of med management and stabilization, and that's supposed to be the purpose. But I think folks think that if you get somebody committed, that that's gonna sort of make everything fine, and then people will come out and magically their life will be better and it'll be okay, but nobody's thinking about, you know, if you don't focus on the community service system, what is gonna happen? Your question after people are released, and typically the kind of politically expedient solutions are focusing just on the hospital piece and not on the what happens afterward, and then we just end up with the same repeating cycle.
And I'm just concerned because it's like, you know, are these people now worse off than they were before because now they are in debt even more? Like now they owe all this money.
I mean, honestly, I think the debt is the least piece of it. I mean, the Federal Reserve of New York actually did an interesting report last year. If you Google it, why it came out of the Federal Reserve is unclear, but they did this really interesting report. They did a deep dive survey, study rather, in Allegheny County in Pennsylvania, and the effects of involuntary commitment on people, where the commitment was sort of, you know, a little bit on the edge, like some professionals would have committed, some professionals wouldn't. And it found for those people that they are twice as likely to die from suicide or overdose in the 3 months after release. I mean, this has a dramatic impact on people's lives, right? This is, it creates trauma. It's, you know, it's an intervention we use. I mean, I'm not saying it's unnecessary in all circumstances, but, you know, I don't think you can underestimate the trauma that it causes for people. And, you know, there are many people who frankly get disconnected from services because of the difficulties of the experiences that they have. It is not pleasant to be strapped down in 4-point or 5-point restraints on a, you know, or forcibly medicated and mind-altering drugs. As you know, it's an experience. And so I think it's that is sort of the greatest harm. And all the stats have always been that I think that with suicide, that the greatest spikes are right in the weeks after people get out of the hospital.
All right. Oh, one more.
I have more of a comment than a question. And it's like, you identified silos as a problem. And I feel in general, for these 2 days, we've seen that silos are a problem. So I just want to comment that we must remember that silos are for corner crops. But in SUD policy and care, they only recreate the problems of the past. We've seen it, fragmented services, duplicated efforts, people falling through the cracks. So I think one of the key filters right now and to the future of this field is what are we going to do with the silos and how are we going to generate real interagency and interinstitutional communication and continuum of work? So we don't have a continuum of work, we keep on siloing, we're never going to fix the problem.
That's right. That's absolutely right. And I think it's interesting because in Kentucky, you know, part of the issue that Louisville Metro has to contend with is, I mean, there's a Justice Department findings letter saying that Kentucky, this is not Louisville Metro's fault, it's the state's fault, you know, is failing to provide community services such that people with serious mental illness are lacking services and are unnecessarily hospitalized and unnecessarily homeless, but it's because of the failure to engage people. So yes, people are on the streets and people are in encampments, but it's, we give them tickets now, but because there is no engagement, because the state is not providing those services. And so it's all of a piece. It's sort of the state doing its part as well and coordinating with the county, which is clearly not and the city, which is not happening.
Well, join me in thanking our panel. Thanks again.